Hello folks, welcome back. So we're going to start diving into the whole securities markets and banking. All right, so it's a lot of information to cover. So I'm probably going to be doing multiple presentations now going forward in regards to dissecting this beast when trying to gain access to our credits. Now that we've laid our foundation, I believe with knowing trust law, the setup there, what's been going on with the three entities. Okay, I'll give a name of the Father and the Holy Ghost, straw man. A little bit of taxing, we'll probably have to go into taxes a little bit more in depth, okay, with how this is administered. But certainly, obviously, securities law, we've got a fundamental basis in knowing as to how to perfect our security and control our securities, okay? And then, just going forward from there, obviously we know our rights and how to stay out of contract. That's the key. With the journey of what we've experienced up until now, especially from my point of view, that can now safely focus on putting ourselves in a position where, we can start negotiating as the bank ourselves that we should be, and or with the brokers who are part of the intermediary infrastructure of this whole security system. Okay, so once again, emphasis on decoding their language, all right, and their words by getting your hands on so-called local commentaries and texts surrounding banking law. For instance, here in Australia, got banking law in Australia, 10th edition, by LexisNexis. Okay, that otherwise I'm going to be going through to show you, some international interpretations, because all of it is pretty much near enough the same, right, of how this is all structured. But just given where you are, there might be different depository trust clearing corporations as compared to the DTCC in the United States, even though, as we know, they're very much an international player on this game, where a lot of securities are eventually sold to or exchanged in the markets on the United States Stock Exchange, okay, and anywhere else that it can go, depending on where the demand is. Okay, once these whole promissory notes and bills of exchange that we create at the back of our signature is created, once it's securitized, it's then obviously deposited at the Trust Clearing Corporation. Here in Australia, it's called Computer Share. Obviously, America, it's TTCC. Europe, I believe, has got their own one. And then it's made marketable from that point forward, where it's then able to be bought and sold, which obviously the major players such as Vanguard, BlackRock, the pension funds, so the guys who are the ones that purchase these bonds, okay, so they collateralize all of these notes into like billion-dollar tranches each. The Treasury issues a bond against it, I believe, and then that is what is then securitized, cleared, and then made available for the open market, which are these guys, BlackRock, Vanguard, pension funds, mutual funds, hedge funds, in order to purchase, to receive the payments, obviously, of everyone on that hamster wheel, servicing that debt plus interest. Okay, so it is fascinating. So we're going to try and work through this methodically, even though there's so much to dissect. Okay, it's a good little chart here. I'm going to upload a lot of these documents in a separate folder under this same module, right? But just to, keep it separated from the rest of the stuff that I've done in the previous three presentations. And otherwise, kick off the back of the Advanced Treasury Pack, where PJP and Pat Devine were kind of leading their ideology and information in regards to their guidance and what they thought going forward is the best thing to do as part of that pack, which is set up your foreign grant or trust in your name as a financial institution. Okay, so you can see here, I did go ahead and start to do this with getting my legal entity identifier, and otherwise trying to break down what it is I need in order to kind of like be recognized as a financial institution within the system, so I can become then a DTC participant, okay, with the FINS form, which you can see here, and the transfer agent letter, okay, that I've sent in with these guys. So I'll just show you, which unfortunately they weren't willing to play ball, okay? So that's kind of what I got back from that. I'll just put it in here real quick. TTCC, I believe it was this email. So I sent in this email with the form. I think I sent it in multiple times. I even tried to phone them up, but they weren't willing to play ball, and otherwise trying to appease the process of what I needed to send in order to then get my foot in the door to then receive a questionnaire, okay, which is otherwise outlined here, which I highly recommend you guys go and read in your own time, which outlines the framework for security settlement systems, okay, because these guys are the intermediary for making private funds public. Okay, as you can see in this diagram here, that we are down here, the purchaser, and then whether it's a car loan, a mortgage, etc., you can kind of follow along. Even though this is mainly geared for America, it's pretty much the same, no matter where you are. You can see kind of what is going on in regards to the transmission mechanisms, where it's then negotiated into the Fed Reserve window. Credits are released in the escrow account, which is normally your lawyer's account, right, that the banks work with in order to keep that arm's length transaction going on, even though it's us that created the funds in the first place. And the DTCC, so the equivalent of the clearing company, that your notes would be pulled together here in Australia, it's called computer share. That is then where it is made public. Okay, and these are the transmission mechanisms. All right, so we're going to be going through this probably in later videos in more in depth as I gain more information about this as well. But this is pretty good in regards to capturing what is going on, because most of them are categorized under the SEC as remix, okay, which are, I believe, real estate, mortgage, investment. What was it again? Let's have a look. Real estate, mortgage, and investment conduit. Okay, so it's a vehicle to pull mortgage loans and issue mortgage-backed securities. All right, because a lot of what these collateral debt obligations are linked to mortgages. Mortgages is otherwise a lien on real assets, and that's otherwise covertly what is going on, because they do, when it comes to land, we are the land. That's what they're putting a lien against. Okay, and it's done via a straw man. Okay, so we're gonna decode all of this, but I'm gonna upload all of it as well for you guys to go through, because it will take a long time to really get your head around the infrastructure, the transmission mechanisms, how it all works. Okay, and the Bills of Exchange Act, all right, which is a key one to decode, that we're going to start to go into, all right, that I'm otherwise going to leave you folks with some links with Bill Turner's presentations, because I believe he explains it probably the best out of anyone else I've come across, as well as obviously the ABCs of the UCC, okay, Articles 3 and 4, kind of brushes on this concept of Bills of Exchange. And these kind of books, commentaries on the banking law, wherever you are, also would have a chapter like in here. It's a really big chapter, chapter 5, Bills of Exchange. Okay, and this is a chapter I'm going to have to go back and read through multiple times. I did obviously cover the Bills of Exchange Act from England's point of view. It's all copied. It's all pretty much the same, depending on where you are in the world. Just skimming over it at an introductory level. Okay, but now it's starting to go into it at a more PhD level, because we're in this more advanced stage now of our journey. But these books will just only aid you folks in gaining that understanding, okay? Because I believe you've got to be so careful, as we'll find out when we go through some of these acts, to not put yourself in a position of committing securities fraud, okay, which otherwise is what's happened supposedly to PJP, which you can gain information on his court case online, okay, which he's a fugitive on the run, God knows where he is, but he unfortunately was done by, I think, issuing one of those checks to one of the banks and got done for securities fraud. And that's something you want to make sure that we're dotting our I's and crossing all our T's before we put our foot in the door with these folks, okay? And like I said, I did try to go through the DTCC. I might try and reinvigorate that process again, but I'm now back in Australia. I'm going to try and do this at a more commercial level, domestic level, now that I can get my hands on the securities that are being traded, which are helping imbue this whole process, okay? And yeah, hopefully it will all start making more and more sense. So I'm going to start with these notes that are taken off the advanced videos from PJP, just to start introducing some of these concepts off the back of the advanced Treasury pack and what these guys are advising going forward. Because just like what we covered in the bond investment book for dummies, some of these agencies and acts and regulatory bodies were mentioned, okay, but there's a lot of different abbreviations, different processes, different applications you must make and comply with in regards to insurance and everything else that goes on. all right, that it's just going to be a war of attrition in regards to chipping away at this. Okay, so we'll just quickly read through this. Then I'm going to go through the main document, which I've kind of pulled together all of my most salient notes on this subject and just whiz through it. And then going forwards, I'm going to spend time really dissecting then what has obviously come before this presentation and how we can utilize this going forward, which it should become clearer and clearer as we gain a better understanding. But really emphasize you folks to go away and watch these videos by Bill Turner, watch this again, read through these documents, get hold of these books, okay? Because I can't emphasize enough that if you want to become a banker and access your credits, you're going to have to know this stuff inside out, okay? So let's get started. So let's go through this real quick. So the secure transaction, this is taken off the advanced video, which you guys, you all have access to on the YouTube, on that website, Robots and Patriots. So it needs a FINS number to go on checks. Now, yeah, anyway, so FinCEN stands for Financial Crimes Enforcement Network, and it offers MSB registrations, okay, money service business, that stands for, which is a legal term used by financial regulators to describe businesses that transmit or convert money. All right, and that's kind of what they're gearing up in regards to what we can use our foreign grantor trust as. Even though, as you'll come to understand, like I have, that strawman name as it is already a bank. It's already a corporation. Okay, that has an account. It's just we need to step in to play the right roles within what's already been established for us when accessing our credits and setting off, okay, that which needs to be set off. Okay, which is another thing real quick. It's going to show you folks. I know it's kind of like here, there and everywhere, but it's going to be like that because there's a lot of spin in place with this process. I posted an update on one of Bill's presentations, right, discussing stamp duty, as you can read here, and he just re-emphasized, which I think was great, just really hitting home, bring it back to basics. Now, there's only two forms of money in circulation at the moment, which is stamps and coins. Everything else is done by set off. Okay, I thought that was brilliant. It's just so short and sweet, bring everything back to basics, and that's what we're going to keep in mind going forwards when going through all of this. All right, we have the right to set off because it's all debt notes. And the only thing of real substance that is money under the true definition of the term is stamps and coins. Okay, so we've got the BSA identifier. They talk about this. Okay, you've got the e-filing system, supports electronic filing of the Bank Secrecy Act forms, either individually or in batches, through a FinCEN secure network. Okay, so BSA e-filing provides a faster, more convenient, more secure, more cost-effective method for submitting BSA forms. So you can see this is just helping to decode how it's all structured. How do I obtain an NCAGE or CAGE code, a unique entity identifier? In order to be eligible to receive an award, all organizations must have a unique entity identifier number issued by sam.gov, okay, as well as a valid registration. Individuals are not required to have a UEI or be registered in sam.gov. US-based organizations, a CAGE code will be automatically assigned when the US organization registers. Okay, CAGE must be renewed every 5 years. The site is there. Grantees may be asked for more information to finalize and must comply with. Foreign-based organizations must apply for NCAGE code before registering in SAMS. Okay, so they got the NCAGE codes must be renewed every 5 years again for that. CAGE code equals commercial and government entity. The unique identifier assigned to suppliers to various government or defense agencies, as well as to government agencies themselves and various organizations used internationally as part of the NATO codification system. Okay, this is all done to try and get your foreign grantor trust into the position of being able to start negotiating now your securities, which are your birth certificates. Okay, in other words, cutting out the middleman by being your own transfer agent. Okay, which is a very complex setup, which is what I mean. You cannot do this unless you fully understand what the heck is going on with all of this that's being administered, for everything that's set up, and what you need under license to practice that which is otherwise illegal without it, okay? So we've got the EDGAR, okay, it's the Electronic Data Gathering Analysis and Retrieval System. It's the primary system for companies and others submitting documents under the Securities Act of 1933, the Securities Exchange Act of 1934, and the Trust Indenture Act of 1939, and the Investment Company Act of 1940. It's a securities filing platform. It can get companies' EINs and other financial information, or type in company's name and Form 10K. Okay, so this is where you can find out information from corporations when you get to the level of being able to do your tax recoupments, if you want to go down the route of the tax revenue side, okay, which I believe you can do, and this is what these guys do, because the IRS, or whatever the equivalent is in that revenue of your country, are the accountants for the bank, which is your SEDI trust. That's a bank, all right, which is all these different bank accounts are basically your strawman name, your birth certificate name. So identifying that account held within the SEDI trust, which is a bank. It's everything's banking, as we know. All right, and that the bond investing for dummies book that went through the previous presentation has really good links. That's why I put that up there in order to start deciphering and getting information about this whole industry. It's Edgar Form ID Application Confirmation, which is SEC. It's a SIC code to log in. That's what you need. It's a CIK, a central index key, or SIC number is a number given to an individual or company by the United States Securities and Exchange Commission. The number is used to identify the filings of a company, person, or entity in several online databases, including CompuStat, in WRDS, and in Edgar. So you need an LEI, legal entity identifier. All right, that's the first step, real easy to get. Again, that's otherwise putting legal name, Alexander George Monolith Trust. That's obviously the name of my foreign grantor trust. And that's kind of like step one, all right, in order to establish yourself as this financial institution that can then go ahead and apply for all these other numbers and licenses, etc. So you've got the standard Form 96, is a tort claim form, lost and stolen securities, sent in as part of initial secured transaction pack. All right, this is obviously when we get in a position of being able to try this out. I'm definitely not there yet, okay, so I'm still learning with you guys. SEC, register for a new identifier as a 144A private security. You have to obtain a CUSIP number of your bond, but this is what these guys are saying, all right? So just going over what they're saying and what they're proving works with PJP's claim, but obviously he wasn't careful enough because he's currently undergoing litigation, all right? It's a fugitive. That's why you're going to be so careful with this. Make sure you dot your I's, cross your T's. Super Account Administrator, all right, FINRA, SAA form. FINRA stands for Financial Industry Regulatory Authority. It is authorized by Congress to protect America's investors by making sure the broker-dealer industry operates fairly and honestly. FINRA is a self-regulatory organization that operates under the SEC, which is a federal government agency. While both agencies protect investors, FINRA primarily regulates broker-dealers and their agents, while the SEC has a broad authority over securities markets. But the FDIC is the Federal Deposit Insurance, which was mentioned again in the previous presentation, provides deposit insurance to protect your money in the event of a bank failure. So a transfer agent, okay, record changes of ownership, maintain the issue of security holder records, and cancel and issue certificates, and distributes dividends. Because transfer agents stand between issuing companies and security holders, efficient transfer agent operations are critical to the successful completion of secondary trades. SEC rules and regulations are intended to facilitate the prompt and accurate clearance and settlement of securities transactions, and that assure the safeguarding of securities and funds. Information about transfer agent registration, inspections, and rules can be found below. All right, and that's the whole role of a transfer agent, which is what they're trying to get the foreign grantor trust to become. Being a participating agent as well as a transfer agent. All right, so you can act as your own middleman, as it were, when issuing your securities or turning your securities or that bond, which is your birth certificate, into a security that can then be traded, bought and sold within the markets. Persons interested in registering as a transfer agent must review all applicable provisions of the Security Exchange Act of 1934, the Securities Act of 1933, and the Investment Company Act of 1940, as well as the applicable rules promulgated by the SEC under those acts before registering as a transfer agent. Okay, and that's why codified in this are the questions and the answers to what you need to put forward and show that you know exactly what's going on in order to qualify to become that. All right, and that's why I'm going to upload that. These documents are definitely worth reading through. Okay, so you guys can slowly accrete more understanding. So qualifying security is any security registered under Section 12 of the Securities Exchange Act of 1934. This is very, very hard to actually find that section. It is illegal to use CUSIP numbers from other instruments. It's illegal to use other routing numbers from other banks. Okay, and that's otherwise what they were getting us to do with the checks, which, you know, if the different Federal Reserve banks in the United States are going to be, guys, just be so careful with obviously people sharing stuff they can get your hands on for free on YouTube. Just look at PJP. And you've got to look in their acts, remember, because their acts is where they tell us what can and can't be done and how things are done. So you have to set your Treasury account up to get your own routing number set up by the Federal Reserve. Okay, the DTCC transfer agency change form is there, then become a DTC eligible transfer agent is there on their website as well, which, guys, I'll upload this so you can click on the links and go and have a look for yourself. That's how I obviously came into this information. I'm trying to draft these letters to in order to appease the process. By that point, obviously, you already have my LEI. There you can see the EIN, and that's the name. All right, and then there's the, I think there's another one. There's 2 letters, okay. Operational arrangement letter. And as you read through the documents you can get your hands on from the DTCC, it basically shows you what needs to be said in order to appease the process, okay? Yeah, so there's that one. There's that one. But like I said, they weren't willing to play ball. So just interesting to see. Okay, but I'm going to be certainly doing that here in Australia. And the company that deals with buying and collateralizing and making marketable all the securities issued by the government and from the banks here, from all the loans that are issued, is Computershare. Okay, and they're actually quite a big company. They operate in multiple different locations across the world, as you can see here. All right, so even in the United States, they all sleep in the same bed, all do the same processes and procedures that's otherwise briefly covered in this chart. Okay, so that's pretty much just introducing the next steps as to if those want to follow and keep going on down that route with the foreign grant or trust, by all means, give it a go. Okay, but now I'm back in Australia, I believe I'm going to try and go for a more grassroots approach and otherwise accrete more knowledge before I even put myself in a position of trying to be able to negotiate with these folks and turning these into negotiable instruments such as bonds, okay, or promissory notes that can hopefully release credit. If by that point I haven't already accessed my trust through what we've obviously covered in those first 2 videos under this module with your claim of expressing your will, you know, to have property disposed of, that's otherwise codified in your local acts for the corporation that you've been registered into. And so, yeah, I'll upload this for you folks. That just otherwise notes again from those videos from PJP. Okay, so we're going to now go into the main notes that I've been taking, okay, from statutes, legal definitions, dictionaries, and also from Bill Turner's presentations, okay? So we've got bills of exchange, promissory notes, bonds, and securities. Okay, what is the difference between a bill of exchange and a promissory note? A bill of exchange is issued by the creditor and orders a debtor to pay a particular amount within a given period of time. The promissory note, on the other hand, is issued by the debtor and is a promise to pay a particular amount of money in a given period. Okay, so we've got Bill of Exchange Act 1909 here in Australia. It's pretty much the same because it's all taken out of the Bills of Exchange Act that was passed first in England, back whenever that was. We've got the year, it's in 19th century some point. So banking includes a body of persons, whether incorporated or not, who carry on the business of banking. All right, now the term banker is a bit more complicated today. Okay, and here in Australia, they call it authorized depository institution. And because the banker's role, they don't take deposits. They otherwise take loans from the public, which anything that's obviously on their book, on their passbook, on their ledger, shows that that's the money actually owed to the public. All right, and they're in the business of purchasing securities. All right, so every time we draft up that loan, as we know, it creates credit on the account. So don't rely on just this definition alone, but it's interesting that it does include a body of persons, whether incorporated or not. And we certainly know that Our birth certificate name is a body, it's a person, i.e. a corporation, and it's certainly a bank, okay, and a trust, which is what a bank really is. You know, all these corporations are pretty much all fall under the category of trust because you're always in contracts, and contracts always fall under the umbrella of trusting the other party in order to perform, okay, whatever the conditions are of the agreement. So bearer means the person in possession of a bill or note which is payable to bearer. Delivery means transfer of possession, actual constructive, from one person to another. Holder means the payee or endorsee of a bill or note who is in possession of it, or the bearer thereof. Endorsement means an endorsement completed by delivery. Issue means the first delivery of a bill or note, complete in form, to a person who takes it as a holder. Note means a promissory note. Person includes, again, a body of persons, whether incorporated or not, such strawman. Written includes printed, and writing includes print. Okay, then we've got part 2, bills of exchange. Bill of exchange defined is a bill of exchange is an unconditional order in writing, expressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money, to or to the order of a specified person or to bearer. Okay, then we've got 77A. When I was trying to look up the requirements for stamp duty, it does seem to me, given this time, that a lot of that has been repealed, okay, in regards to them requiring us to use stamps on these negotiable instruments such as bills of exchange and promissory notes, okay, but this is something obviously you have to do a little bit of digging, but this is otherwise what they may be alluding to in their acts, okay. So effective non-compliance with stamp laws in case of certain bills of exchange. A bill issued in Australia which is presented for acceptance, accepted or payable outside of Australia shall not be invalid by reason only that it is not stamped, okay, or is not properly stamped in accordance with any law for the time being in force requiring that bill to be stamped, and any such bill which is unstamped or is not properly stamped may be received in evidence on payment of the proper duty and penalty, if any. So basically saying that, similar to the inchoate setup, okay, if you deliver a bill and it's inchoate, then any person can see to it to complete it by filling out as necessary, okay. And it's kind of the same applies with the stamps, it seems. So part 3, checks on a banker. A check defined. A check is a bill of exchange, so there it is again, drawn on a banker payable on demand, except as otherwise provided in this part. The provision of this act applicable to a bill of exchange payable on demand apply to a check. Okay, now check is a little bit more, again, there's more advanced interpretations with that in later acts such as the Check Act, I believe here, the Check Duty Act, whatever it's called in Australia. And there's probably going to be a similar commentary or interpretation act given where you are, and certainly within their banking law commentaries books, they go into more depth surrounding that. Promissory notes. A promissory note defined is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. An instrument in the form of a note payable to maker's order is not a note within the meaning of this section unless and until it is endorsed by the maker. Okay, a note is not, which means signed. Endorsed means signed. A note is not invalid by reason only that it contains also a pledge of collateral security with authority to sell or dispose thereof. A note which is, or on the face of it, purports to be both made and payable within Australia is an inland note. Any other note is a foreign note. Okay, it's just we're going to skim over this just to give you, to introduce it, all these terminologies, vernacular again, and then we're going to be diving deeper into it in following presentations. So we've got the Check Act here in 1986. Check defined as a check is an unconditional order in writing that's addressed by a person to another person, being a financial institution, okay, and is signed by the person giving it and requires the financial institution to pay it on demand a sum certain in money. In this act, financial institution has a restricted meaning. See the definition in subsection 3.1. Okay, so an instrument that does not comply with this subsection or that orders any act to be done in addition to the payment of money is not a check. All right, so we also have under international law, the United Nations Convention on International Bills of Exchange and International Promissory Notes. Now you've got Article 1. This convention applies to an international bill of exchange when it contains the heading International Bill of Exchange, Unicentrale Convention, and also contains in its text the words international bill of exchange, Intercontrol Convention. Likewise, the same applies to the promissory note, international promissory note, Intercontrol Convention, etc. So Article 3, again, just reiterating what you've seen in the domestic acts. A bill of exchange is a written instrument which contains an unconditional order whereby the drawer directs the drawee to pay a definite sum of money to the payee or to his order. B is payable on demand or at a definite time, is dated, and is signed by the drawer. A promissory note is a written instrument which contains an unconditional promise whereby the maker undertakes to pay a definite sum of money to the payee or to his order, and is payable on demand at a definite time, is dated, and is signed by the maker. Okay? And guys, if you want to watch the articles, ABCs of the articles 3 and 4, it will help give you some more information and a good presentation there as to who the drawer is, who the drawee can be, as well as the payee, and that kind of three-party relationship again. And if you, again, once you get that embedded in your head, you can start to think how we have been split in three too. Okay, so we've got two other entities apart from our living self that is certainly linked, two of them of which are linked in the world of commerce, one of which is, again, the name of our father, which is our surname, which is identifiable as the crown, corporate crown, Securitization Trust, and then we've got the Holy Ghost, okay, which is the straw man entity, which again is another corporation, and it's an account and a trust and a bank. It's otherwise held within the much larger trust, which is the surname Securitization Trust. Okay, then we've got a given name coming in, so you can see how potentially we can be negotiating with this trinity that's been set up as drawer, drawee, and payee. Okay, just some light bulbs went off for me when obviously knowing this three-party relationship now within the bills of exchange and within the Holy Trinity set up from our birth. So I've got some presentations here that are like must watches for you folks in regards to understanding this topic. Okay, you got the endorsement, bill of exchange presentation, which I highly recommend you folks. You need to learn this inside out. Okay, so it's going to take time. Watch it multiple times. Again, get your hands on the books. Can't emphasize enough. Read the chapters with commentary, even comb through the Bill of Exchange Act yourself, and you'll start to see how then, once you have the knowledge of what's going on and what's codified in that act, how we can start using it for our benefit, which is what Bill Turner starts to get into when alluding to accessing the account that is already there, as we know, because that's otherwise what they're administering, okay, which is here. Your account funds all of your commerce, which is Securitization Trust. This trust company holds the funds to your Securitization Trust in the amount of millions of dollars, possibly billions. Some of you, if you've been good little taxpayers over your lifetime, I haven't, but we're certainly going to be enough in there. So this is otherwise what Bill goes into in his presentation, that you've got the links there, okay, that when you understand this stuff in regards to what acceptance means, okay, when it talks about delivering at a different place other than where it should be paid to be accepted, to then forward on to the payee, which in our regard could be the Treasury, all right? These folks who can then access our trust to have things set off. Remember, set off. There's only ever set off unless you're paying in stand, which is the consideration. Okay, so anyway, we're going to go into this in more depth, but it's up to you guys to go away and watch these presentations that otherwise also highlights again this setup of what's going on, okay, in regards to you getting a loan. Okay, you sign that note. So you're buying a house, you ask the bank for a loan. Bank sends a note, a loan agreement to the Reserve Bank. You sign the note, right? RBNZ notifies bank to issue credit after sending it to the Reserve Bank. The Reserve Bank then sends it to the Central Securities Depository Trust. So that's the New Zealand's equivalent of DTCC, but it's now also the Computershare. Okay, the company that does that now is Computershare, which lodges securities, sells to markets. You then sign, obviously that's where you sign the loan agreement, bank credits lawyers, trust account, and draws up the mortgage agreement. Again, this is where the escrow account is set up. who receives the funds, when in reality it should go directly into your account to access to fund whatever it is you're purchasing without having to pay it back. And then the lawyer lodges the bank's instrument at liens against the title deed of now, which is the mortgage agreement. Okay, so the mortgage is basically the lien on the property, which, as we know, which is why it's all mortgage-backed assets, securities, and the land is also just the title deed as it goes into, which is otherwise linked to your trust account. So it's your trust account, CDKV trust account, that's actually being liened against. But due to us stepping up and paying surety to the straw man, we cop the burden of having to perform. All right, and they subrogate the roles. And then you sign the mortgage agreement, then you're locked in to the death grip. I'm going to serve that even though you're the one that funded it in the first place. So that's, again, another rudimentary snapshot as to what goes on. Okay, that's otherwise explained in this presentation. Down here, banking practices in simple English. And it goes into the valuer's insurance. Okay, so if anyone forecloses and the house has to be sold quickly at a discount, the insurance comes in and fixes the difference. So the bank never loses money. The banker in the ball game of Monopoly always wins. And you got this one, okay, goes into the promissory note. So it's interesting. You've got both the promissory note he mentions. That is then the note that is used to credit the account and negotiate at the Fed's window. But there's also other presentations he mentions about the birth certificate, okay, and that the loan agreement gives them the power of attorney to then go purchase one of these, okay, which is probably also used with the promissory note that's attached to it to show that this is now what has to be leaned against it, and that's otherwise what then releases the credits on account linked to your straw man name. Okay, because we all know it's all linked to this account. That is in the name of the Holy Ghost. So I'm going to actually play this to give one aspect of this before we then move on to the next. Next part of the Word document. We'll just speed up a little bit. I'm going to have to turn the volume down so it echoes. That should be right. All right, let's play.
Today we're going to learn some things that are probably pretty close to our hearts because the monetary system has controlled us for many, many years. And one of the key things has been the loan market and how we go to banks to apply for loans and things like that. So today we're going to be looking at a few of their secrets. We're going to find out how they create the money, and this is very different to what most of the gurus have taught you over the years. I will show you exactly what they do, but I'm also going to show you how they con us, because there are a few little tricks that we need to be made aware of. Okay, so the first thing we need to learn is what is a security. If you don't know what a security is, you're never going to understand how a bank works. A security is a form of ownership in an entity. Okay, so the entity that we're talking about here is the CDKV trust, the straw man, the person, whatever you want to call him. While some believe that in order to be a security, the instrument must be traded on a market, the legal definition of a security is much broader. The definition is important because the instrument, or if the instrument is a security, then the federal and state securities law apply to the purchase and sale of that instrument. So these securities get purchased, they get sold, and these securities earn interest and all sorts of other things. So let's delve a little bit deeper into the Securities Act 1978, which is the New Zealand legislation. And in this act, unless the context otherwise requires, the term security means any interest or right to participate in any capital, assets, earnings, royalties, or other property of the person, right? We already established what the person was in the previous slide. It's the CDKV, it's the strawman, whatever you want to call it. But it also has an interest in a superannuation scheme, a unit trust, a debt security. Okay, so you'll find that these securities are trading with the QSIP number. So if you apply for your QSIP number, you'll find out exactly how much these securities are earning. So the superannuation policy is put on the life of the trust, but the trust is dependent on our life. So there is a superannuation scheme, life insurance policy in place that is trading, you'll find that with your QSIP number, and you'll find how much they're worth. And there's a substantial amount in them, I can assure you. Okay, we'll move along to how they actually create the money. And this may surprise you. When we apply for a loan, there's only one thing they need from us. They need a power of attorney. So if they have a power of attorney, now they can access our trust. Plain and simple. They're Crown agents, they can access our trust. And this is how they do it. The moment they get power of attorney, they order a birth certificate. Wonder why? Oh, birth certificate's on security paper. And on the back of every birth certificate, there will be a different number. I've ordered many birth certificates over my time, and everyone has a different number on the back because they are like a blank check, which we will now discover how they create the money. The reverse side of the birth certificate is blank or inchoate. Maybe a new word for you. So let's look at the 1908 Bills of Exchange Act. Inchoate instruments, where a simple signature on a blank stamped paper is delivered by the signer in order that it may be converted into a bill. It operates as prima facie authority to fill it up as a complete bill for any amount the stamp will cover. Okay, this is how they do it, folks. They order a birth certificate, they turn it over, and they complete it. But what do they do, you may ask? The bank writes a bond on the back of the birth certificate. Now, these bonds are then sent to Computershare. They used to go to the Treasury, but in 2010, because the old system, the age of Pisces, was coming to an end, the new system came in 2012, but it hasn't been completed. There's still a lot of people kicking and screaming out there, but so Computershare now is the one that does all the bonds. What they do with these bonds is they bundle them up, probably into a $1 billion tranche, and then they put them out to the market. Now, the main ones who buy the bonds or who purchase the bonds would be pension funds, trustee companies, Vanguard, BlackRock, the likes. They would purchase these because they have a coupon rate, and the coupon rate is very important to them. It's a very low rate, normally between 1% and 2%, but they purchase them because it's a good, steady source of income for them. Computershare float the bond. The bank is notified when the bond is picked up. Now, Treasury used to hop on the phone and say the bond has been picked up. So what would happen next would be that the bank would call us to confirm that the loan is approved. Okay, now they will never put in writing that your loan has been approved. All they do is give us a call and say your loan is approved. Now something very different happens. Let's just call it sleight of hand. These two fine young gentlemen here. The bank deposits the funds into the lawyer's trust account. And look at them, they're fine young gentlemen. They call us to sign a mortgage agreement. Now, remembering we applied for a loan, not a mortgage. But because the bond has gone out to one of the major institutions, they need to get the coupon rate. So when we sign the mortgage agreement, that means that we are going to be paying a coupon rate to the purchase of the bonds, and the remainder of the interest rate goes to the banks. These two fine gents, they're not finished yet. There's one more little trick they've got up their sleeve. Oh, I forgot to mention the reason that the banks do it the way they do. They now have an arm's length transaction when they give it to the lawyers. So the arm's length transaction, they say, oh, we had no idea that the lawyers were going to do that. We'd put it into their trust account for safekeeping. They wouldn't pull a swifty like that, would they? But these two fine gents, they've got one more little trick up their sleeve. They ask us to sign a change of address. Now, when we sign that change of address, guess what happens? Because there is a charge against the land being us, they get the change of address and they say, here is who you will charge. They send it off to the local councils, and same as land tax, they send it off to the local councils. The local council now knows who to charge rates or land tax to, the land that they will put that charge against. So That's how you end up paying rates. If you don't sign that, or if you actually read that change of address, you'll see exactly what I'm saying there. So in summary, banks are agents for the trust. The power of attorney gives them the right to act as administrators of the trust. Now, being administrators, they get their commission for doing that. Now, I hope this very, very simple and short video has explained it to you in a lot more correct way than what a lot of the other people are telling you out there. And now you can start asking questions, sharing your knowledge. Remember, knowledge is power. The more that you share it, the more information will come to you. Good luck out there, guys.
You see that there's slight nuances in the other presentations, but you'll be able to discern for yourself in regards to, obviously that's for a mortgage.
We've been rethinking beginning Greek at Biblical Mastery.
Ultimately, everything ends up becoming a remake once they're pulled together. Okay, because it's all leaned against the land, which is us, held at the land registry. And that's why the lawyers get involved. That's why the underwriters would get involved, the transfer agents and the solicitors there. Every step of the way, whether it's a direct mortgage on a house purchase or pooling a load of these loan agreements for car purchases or anything else, right? And even credit cards, okay, would be securitized. In fact, lawyers would come in, underwrite it, and they do this thing in regards to finding it against the title, the land held at the land registry, the title that's held there. Okay, so with the land. Ashes to ashes, dust to dust, as they say, even though that's not the case. If you're unlocking the ability to ascend, which is what we should all be doing, coming back into eternal life. So I'll leave that there for you guys to look through. Really, really good, really important, I believe, in order to fully understand inside out, especially the bill of exchange. Okay, if you spend your time in understanding the bills of exchange and this concept that the only money that we have at the moment is stamps and coins, and everything else is done via set off, it'll put you in good stead going forward, and the rest is just easy in regards to becoming familiar with the map of the transmission mechanisms of how this all works and what it is we have that we can then start negotiating, as he alluded to, which is a blank security, blank check, pretty much. Okay, so look at a few definitions. Securitization, the substitution of loans by marketable financial instruments. An example is when bank assets such as loans and mortgages are sold to a company which raises funds by issuing negotiable securities. Beneficial ownership of the assets is shared among a large number of small investors. Securitization began in Australia with bills of exchange and promissory notes, where something otherwise unmarketable, a loan becomes a marketable asset. It circumvents the problem of a debt, such as a mortgage simply remaining on the lender's books until eventually repaid. To securitize, verb to convert assets into negotiable securities for resale on the financial market, allowing the issuing financial institution to remove assets from its books and thereby improve its capital ratio and liquidity, and to make new loans with the security proceeds if it so chooses. Then we've got something that secures or makes safe, okay, right to resort to some property or fund in order to guarantee payment. And then the corporation is a document issued by a government, semi-government body, statutory body, or public company in return for funds invested for a specified purpose by purchasers. Such securities are marketable. Okay, that's why they've made us marketable. They've made the straw man marketable, okay? Which is what Bill alludes to and why they print it on very fancy security paper, as outlined in my doing the forensics on the forms presentation. They include bonds, debentures, shares, units, and interests in management investment schemes. Okay, the relationship between purchaser and borrower varies in each case. Some securities carrying a fixed rate of interest and a date for maturity. In the case of shares, money is invested without certainty of income, appreciation, or eventual recovery in the case of liquidation. For the purpose of Chapter 7, a security is defined as an option to acquire by way of issue a share in or a debenture of a body, whether a legal or equitable right or interest, but does not include an excluded security. So we have an equitable right, an interest in our strawman CKB trust account. Okay, they have legal title. So the ones who administer and control the accounts and establish the accounts, right? But we have an equitable interest and right to that. So what is the difference between a debenture and a bond? Bonds are debt financial instruments issued by large corporations, financial institutions, and government agencies that are backed up by collaterals or physical assets. Debentures are debt financial instruments issued by private companies, but any collaterals or physical assets do not back them up, and it's relied primarily on credit ratings, of that individual's ability to pay back their debts. So the collateral backing government bonds are the people, us, through our lifetime of labour and tax payments, which is transmitted through us, stepping up as surety for the straw man, which is why they securitize that entity. Thus, the birth certificate security in and of itself represents the capture of life force, this is my commentary, and lifetime of labour and tax/debt repayments for at least a good 30 to 40 working years that the governments can negotiate to back their issuance of bonds. Of course, this is completely dependent on us stepping up to play the role of surety when conditioned into thinking we are that corporate entity, which they manage to entice from the many benefits you can receive from coming into their system. The same procedure happens through the private banking infrastructure. You get a loan, that loan is a promissory note. It also gives them power of attorney. It makes you the customer who has to pay. That promissory note is then backed by your birth certificate, which they obtain, and they take that note with your birth certificate to the central bank in order to release credits in escrow. And the central bank, obviously, as we know, the central bank before that obviously deposits that note to the Depository Clearing Corporation or the equivalent, wherever you are. Here it's Computershare. America it's DTCC. Europe will be something different, where they bundle a bunch of those notes in pools, tranches, securitize it, and the Treasury issues a bond against those, and the bond gets bought and sold in the markets. The banks and governments merely act as pass-through entities to the holders of those securities who receive the interest and principal upon maturity. So I've heard Bill say the Treasury does issue bonds against that. So we're going to, like I said, in the future, as I dig a little bit deeper, I'm going to really try and find out and hone in to see exactly what is going on. So we can actually break down and see exactly what is happening, especially for me being here in Australia. In other words, see how it's happening on the private side, even though it's all private company, so-called disguised as public, with the government issuing, Treasury issuing bonds, off the back of the taxes of the people, pledging us as collateral, but also the banks. The banks, they're kind of like these transmission mechanisms, and these guys are conduits, whether it's coming in from the government level, which is doing all their appropriation bill, so funding to pay for the bills that are passed, right? Appropriation, which obviously is funded all through issuing bonds, and then they raise revenue through taxing us through that entity, the straw man. And then you've got the private banks, so getting loans at the bank. They're all extensions of our trust account, and these transmission windows and mechanisms that eventually create the credits on account within the system. At the Fed's window, then the DTCC. So the banks and governments merely act as pass-through entities to the holders of those securities who receive the interest and principal upon maturity. All right, we've got a certificate. Out of Black's law is a document certifying the bearer's status or authorization to act in a specified way, especially an official paper stating that one has completed a course of study or passed an examination, example, nursing certificate. 2, a notice by one court to another court of the action it has taken when issuing its opinion. The 7th Circuit sent a certificate to the Illinois Supreme Court. 3, a transferable security consisting of an official voucher showing ownership of a share as in a joint stock company. And 4, a document in which a fact is formally attested, i.e. death certificate. And that's obviously, this is the most important definition for us, given the situation now and what's going on for these accounts. And also, when knowing that the birth certificate can otherwise be construed as a death certificate, so it's identifiable of the birth, the creation of this dead fictional entity, this dead corporation. Stock certificate is an instrument evidencing ownership of shares of stock, specifically an official document showing that one owns shares in a company, also termed certificate of stock, share certificate. Again, a certificate is a written document setting out certain facts in full recognition of compliance with statutory or administrative requirements. It may be a prerequisite to enable controlled activity to be carried out. See also certification. Now, I'm just going to show you an email that I sent to birth, deaths and marriages that otherwise confirm this fact. So I was asking questions about what the numbers were on the back of the certificate, etc. Okay, and she returned saying, the number listed on the back bottom right of the certificate is referred to as the security stock number. That's interesting. Security stock is the paper we print the certificate details on. The number is unique for each piece of security stock paper and runs in numerical order. This does not indicate the number of certificates that have been issued. The number listed on the front bottom left of the certificate is referred to as certificate number. This number is unique and does not run in numerical order. And then anyway, this is on the extract. That number is referred to also as the security stock number. Okay, so isn't that interesting? Isn't that very interesting? So just confirming what this birth certificate is. So if anyone out there is saying that you can't monetize it, they're barking up the wrong tree, okay? And they're otherwise missing out on how you can access your credits. And like Bill says, it's a blank check. You just got to learn the Bills of Exchange Act, the Checks Act, the securities law surrounding all this in order to start negotiating it. So this is my commentary. The birth certificate represents a straw man, as we know, which is the corporate token issued by the government. This entity transmits energy, so transmitting utility, from the real woman or man to the corporation that created it, which is the government, and all other corporations and instrumentalities it engages with. It is a vacant position and needs an agent representative to charge it with life, the cash flow, as does every company, right? Every corporation that exists. The cash flow / revenue stream that's created from this entity comes in the form of labor, products and services, tax payments, loans and interest repayments, and insurance policies that are taken out in the name. Thus, the strawman. Thus, it itself is an instrument that can be negotiated and traded in the markets. The entity is a marriage between the living given name and the name of the father, which is the surname. So it is a hybrid between the state and the living son / daughter. And even though the state created it, it would never have been created if it wasn't for our very presence and existence. Thus, we do have an adverse claim, a right in recoupment, and a right, equitable right, to use it without becoming surety for it. In other words, receive the dividends, proceeds, share of the monies being made in that name from the trust, said the KB Trust, as well as accessing a right to issue credits in that name too, which is how the whole banking system infrastructure works. The birth certificate is printed on security stock paper, signaling that this entity has been made security for all of the national debt and is considered stock, intended purpose by way of capturing the activity, duties, and obligations of its user, us. That is then pledged to issue more bonds to the central bank that releases credits on an account with zero balance, because we are the ones who service that debt in interest by virtue of paying taxes and producing all the goods and services that are also taxed. Okay, so it's right. A lot of it is the tax. The tax is how they collect to pay off and service the interest due and all the debt that the government issues with these bonds, okay? Which then goes towards paying the holders of those bonds, which are the big international players like Vanguard, BlackRock, the pension funds, the mutual funds. So it's all like this mad, insane wheel that kind of, we create the credit, they subrogate, they get us to pay it back, but then it ends up in the hands of the elite, the people who know how to play the game, which then also funds some of the pension funds for people retiring. So anyway, we're going to decode it and so we can fully understand, look at the bellies of the beast, disembowel it, okay, and then put all the pieces back together, do an anatomy lesson. So biology in the securities market. So stockbroker, someone who buys or sells stocks and bonds as an agent for others, also termed account executive and account representative, okay? So we're going to be probably dealing with these guys. I'm in contact with one. So it'd be very good for you guys to start bridging communications and contact with fellow stockbrokers, okay, in order to start having good conversations after gaining the knowledge of knowing what we're going through now. Negotiable instrument from Black's Law is a written instrument that 1 is signed by the maker or drawer, 2 includes an unconditional promise or order to pay a specified sum of money and is payable on demand or at a definite time and is payable to order to bearer. Okay, where have we heard that before? Obviously codified in the Bills of Exchange Act, and it's also put in UCC subsection 3104A. Among the various types of negotiable instruments are bills of exchange, promissory notes, bank checks, certificates of deposit, and other negotiable securities, also termed negotiable paper, negotiable note. Guys, ABCs of the UCC Article 3 and 4. Again, another one there that can just help with your understanding in the subject. This is a commentary under the definition. What are called negotiable instruments or paper to bearer, such as bills of exchange or promissory notes, do really pass from hand to hand, either by delivery or endorsement. giving to each successive recipient a right against the debtor, to which no notice to the debtor is essential, and which, if the paper is held bona fide and for value, is unaffected by flaws in the title of immediate assigners. Okay. One must first understand that negotiable instrument is a peculiar animal, and that many animals calling for the payment of money, and others loosely called commercial paper, are not negotiable instruments and not subject to the rules of Article 3. All right, like I said, it's really worthwhile going to get a banking law commentary in the nation that you're in and read the Bills of Exchange chapter, okay, which I think I'll put another presentation together under this advanced section, really decoding it and explaining it with commentary of my own and how it can apply to our situation, like Bill Turner does in some of his videos too. Because it's so important to know inside out. Negotiable instrument, this is from LexisNexis. Okay, it's a document recording a chosen action. Think chosen action is otherwise like a bank account. Okay, so funds held in a bank account at a bank, such as a promise to pay money by one person to another or direction by one person to another to pay money to a third person, with the following characteristics: the ability to transfer the property rights recorded on the document by delivery or by signature, endorsement, and delivery of the document itself, unless the document, being a bill, is marked non-transferable, and without immediate notice of the transfer to the person against whom the rights are to be enforced. An instrument so transferred is said to be negotiated. The ability to sue on the property rights recorded in the document in the name of the person who currently owns the rights, being the holder of the document, and the transfer not being subject to equities, so that a transferee in good faith, full value, prior to the maturity date of the instrument, and without notice of prior defects in title, such as fraud or theft, can acquire a better title than previous holders, free of defects in title or personal equities between remote prior parties. Okay, it's Bills of Exchange Act 1909. Negotiable instruments include those under Bills of Exchange Act and Checks Act, and those recognised by general law based on mercantile custom and usage. Bearer securities, negotiable certificates of deposit, dividend warrants, some government and corporate bonds, warehouse certificates, and possibly traveller's checks. Now, under the personal property securities, similar to the UCC Registry. So for the purpose of the Personal Property Securities Act here in Australia, instrument including not only a bill of exchange, check, promissory note, and writing evidence of the payment right, where the writing is transferable by delivery or satisfies requirements for negotiability, but also a letter of credit requiring presentation on claimant payment. Okay, see also bills of exchange, check, promissory note, letter of credit, writing. So anything with your name, date, amount, signature on it can be negotiated and is deemed money within this system, or negotiable instruments, the correct term. Money is, remember, stamp and coins. Registering the instrument makes private funds public, and by securitizing it in the form of underwriting, insurance, it can then be made marketable as per the definitions, which by the conventional route is quite hard to do, as you need to purchase a security identifier like a QSIP, SINS, ISIN, and will need someone to underwrite the security to make it eligible for trade within the markets, which is often done by a solicitor. Then you'll need a transfer agent, participating agent in one of the security depositories, okay, to register it in the market's books. It is my opinion that anything that comes on security stock paper, like a birth certificate, has already been underwritten, assigned a unique identifier, and that's ready to be turned into a negotiable instrument and sold in the markets, whether that be an international promissory note, bill of exchange, or a bond, thus saving us time and having to fulfill the requirements. However, as proven with my surety bond case for car insurance, that was accepted as valid insurance of my car, where it did not even register the bond, assigned my own reference number to it, and witnessed/underwrit the bond with two variations of my name, which was bringing in almost the surety. So the two witnesses were like two variations of the straw man name, which can be different derivative contracts and accounts that probably held on account under the said KB trust. This is the thing. This is why when you start thinking about how these securities are governed, and now that we've got two entities on the corporate side, the surname and the Holy Ghost name, and we're coming in our living capacity, we can certainly use one or two of those to witness as well as underwrite and act as surety for one another. Okay, so it's pretty powerful when understanding how you can play both of these guys, or all three, including us. So I'll just put here example of an international promissory note. Okay, this is otherwise taken from a PDF that claims that it can be used to discharge debt or set off debt, but not to draw credits on an account that you have with the bank that you can then access to spend on whatever you want. All right, so just an example of seeing how it's appeasing, what's otherwise codified under international law and domestic law within the Unicentrale and also UCC and the Bills of Exchange Act. Okay, and just, you do a bit of homework and see and check off. Okay, he's got the signature, he's got the drawer, he's got the address, the amount, some certain, he's got a medallion stamp, etc. Right? Some security paper document, security features in the paper. But you've got to think, you don't need to go to that extent. You've already got, if you can get your hands on any unlimited number of these, how you can then start negotiating it by putting the promissory note or the bond on the back of that. So you can see above an example of an international promissory note that fits the requirements in law for it to be considered a negotiable instrument promissory note. These are claimed to have worked to pay for outstanding debt, but not to credit an account. Up to you to do your homework and qualify for yourself. So we've got instrument. Definition out of Black's law is a tool, a formal legal document in writing, for example, deed, will, enactment, agreement, or guarantee. A formal document of any kind, such as an agreement, deed, charter, delegated legislation, or record that is drawn up and executed in a technical form. For example, see that case, an instrument includes a statutory rule made under an act and a written document and a written statement. See also agreement, deed, document, forgery, human rights, instrument under hand, utter. Security interest, a property interest created by agreement or by operation of law to secure performance of an obligation, especially repayment of a debt, specifically an interest in personal property or fixtures securing payment or performance of an obligation. Although the UCC limits the creation of a security interest to personal property, the Bankruptcy Code defines the term to mean a lien created by an agreement. Okay, so that's out of Black's law. We must also control any securities we make up, whether it be a bond, bill of exchange, or promissory note, and control it on a securities register by adding it as collateral to part of our estate and assigning it to the drawee/bonded agents we issue it to. That way we protect the asset against salvage. So remember what we learned in the Advanced Treasury Pack, how to, register it under the postal UPU, and then that's how you make, private funds public, as they claim, and then control it by registering it on the UCC1. Then you can also look at assigning it to those individuals that you wish to assign to if you're going to indemnify yourself, okay, or whatever it is you wish to do to negotiate that instrument in order to protect it against it being kind of salvaged, as it were, and hold these guys accountable where they are bonded then to perform based on the terms and conditions of the bond, which we'll look into the definitions of bonds. And this will give you a lot more food for thought when going forward in terms of being able to access your remedy here in this life, okay, this wonderful knowledge. So security agreement is an agreement that creates or provides for an interest in specified real or personal property to guarantee the performance of an obligation. It must provide for a security interest, describe the collateral, and be signed by the debtor. Okay, the agreement may include other important covenants and warranties. As we know, it's a very important document that makes us the entitlement holder. As soon as you file and make that public, you become the lien creditor, and everyone's notified of your position, which is held under the security agreement of the debtor-creditor relationship. Okay, and you can also, if you think about this relationship we have now with the three entities, you can have the Crown, Middleditch, for instance, for me, Securitization Trust with the birth registration number, which is the identified marker of the trust account, owe money to or issue a promissory note to the strawman, okay, which is obviously on your corporate side, something that you can control as a secured party and creditor, with you being in your living capacity is just your given name under your born identity. Okay, and then you can use that strawman to receive money on account that's otherwise drafted from the father, which is the Securitization Trust. So, all these ideas are starting to spring into my mind now, coming into this knowledge of knowing how to play the game and what has actually been set up. Okay, so this is just a screenshot that I've taken out of the PPSR here in Australia, when I've started to look at some definitions of some of their terms in regards to what they mean when it comes for me to file domestically here. Okay, so I'll just skim over it. So it's all pretty much self-explanatory that you guys can obviously read through in your own time. But saying here, when I go into the Bay law, okay, personal property securities writing issued by or addressed to a bailee covering goods in the bailee's possession and containing, this is under documents of title, and containing a statement that goods will be delivered to a named person or order to the bearer. The goods must be either identified or fungible portion of an identified mass. An example is a bill of exchange, bill of lading. See also Bailey, bill of lading, financial property, fungibles, goods, writing. So we have possession and control of the straw man by being the holder of the certificate and also have a right to ownership of the property, which is why they do what they do to declare us dead so that ownership can escape to the estate, because you can't pay out to a dead beneficiary. All right, we've gone over these definitions in other papers that you guys can read through in your own time. This is all geared towards specifically here in Australia, but it's obviously all pretty much the same. So an investment instrument is an investment instrument includes a share, a bond, a debenture, a derivative, a foreign exchange contract, an option for the allotment of an investment scheme, a unit in a share, and a financial product. So I just did that in order to understand that if I'm going to issue my own negotiable instruments, what category they'll fall under, right? Security agreement would be chattel paper, and obviously document title is document title, and then you've got all the different terminologies there, so that's why I put that there, okay? So you guys can kind of do the same if you're in Canada, for instance, or New Zealand, or another place that has their own domestic securities registrar. I would also be doing the same, but on the UCC international level too, but especially when dealing more intimately with this process of your central bank and or depository trust clearing corporation equivalent, here it's computer share, that you certainly will want to be dissecting your local securities registry services, okay, which here is the PPSR. So here's obviously the example of the surety bond, all right, that I did when insuring my car, okay, that obviously we all are familiar with that case, where they issued a letter of apology, okay, because otherwise, basically indemnify myself, but this was so rudimentary, okay, so going forward, this is where we're gonna have to make this more concise and succinct, so we can squeeze it into being printed on the back of a birth certificate, okay, and get a little bit more, I guess, better with our words when putting in the terms and conditions of what's going on, who's going to be jury, and what we want to achieve with the bonds that we can issue. Okay, so we're going to now look at the definition of bond, and this is taken out of Black's Law, which has an example of all these different bonds I highly recommend reading through, become familiar with, because you might see some of these type of bonds that you may want to issue. Okay, we've obviously been introduced to the surety bond, all right, which is private bond for set off rather, for the insurance for my vehicle up to £1 million sterling. Okay, that worked. That showed you guys as valid proof of insurance. However, I've not been able to prove that I was then able to get Grant Shapps to draw on an invoice that had been drafted to me, a bill that had been drafted to me for an accident that I may have had to cover as compensation, right? That this bond relationship would have, under law, especially if they wrote the letter of apology, that they would have had to cough up if that was ever to happen, okay? So unfortunately, I never went through that to prove that side of it, but certainly proved that this negotiable instrument was valid proof of insurance. Okay, so it's just a matter of going through this document again and looking at, okay, well, it shows that you've got a bond here, all right, that if called upon, you've got £1 million, but who's going to pay it? It's obviously going to come from my trust accounts, and that's the whole deal with these things, but we're going to, again, scrutinize it and try and become expert at this level and condense it and, make sure it fits in the back of the birth certificate, but also consider all of these other bonds, okay, which obviously we've got the indemnity bond introduced to in the advanced Treasury pack and the set-off bond. Okay, and then obviously before that, we had a example of a very rudimentary set-off bond, okay, that worked. That just goes to show you don't need to be fancy with these things, because if it is in Kuwait, they can come along and complete it if there's anything missing, as I said before, but we'll go into this more in depth. Coming in, obviously got the correct grammar there, which is separating, my living name, which was given to me, to the name of the father. And we got the straw man name as well, which is, again, the kind of witness one, another representation of my name, but it's kind of implying the given name, the living capacity, and then the straw man as witness two, which is almost like underwriting the principal here, which is me, Alex Middleditch, okay? But we're going to be so careful with not being the principal debtor, with our language, in other words, the principal creditor, in trying to get the Grant Shapps and these folks to be the debtor, okay, in order to perform for our benefit, in order to draw on our strawman trust account. Okay, so this is otherwise, yeah, where we're going to be spending most of our time, me spending most of my time going forward in dissecting this. Okay, but these different bonds and going through these definitions is going to reveal a lot. Okay, so bond as a noun is an obligation, a promise. Okay, an obligation, or in English, a bond, is a document written and sealed containing a confession of a debt. In later times, contract is the genus, obligation the species. All right, so 2 is a written promise to pay money or do some act if certain circumstances occur or a certain time elapses. A promise that is defeasible upon a condition. Subsequently, especially an instrument under seal by which 1, a public officer undertakes to pay a sum of money if he or she does not faithfully discharge the responsibilities of office, or 2, a surety undertakes the responsibility to pay if the public officer so fails. So the fact that an instrument is called a bond is not conclusive as to its character. It is necessary to disregard nomenclature and look at the substance of the bond itself. The distinguishing feature of a bond is that it is an obligation to pay a fixed sum of money at a definite time with a stated interest, and it makes no difference whether a bond is designated by that name or by some other, if it possesses the characteristics of a bond. There is no distinction between bonds and certificates of indebtedness, which conform to all the characteristics of bonds. And that's taken out of Black's law. So we've got a bail bond, okay, is a bond given to a court by criminal defendant's surety to guarantee that the defendant will duly appear in court in the future, and if the defendant is jailed, to obtain the defendant's release from confinement. The effect of the release on bail bond is to transfer custody of the defendant from the offices of the law to the surety on the bail bond, whose undertaking is to redeliver the defendant to legal custody at the time and place appointed in the bond, also termed appearance bond, personal bond, recognizance. Okay, and see bail, purge bond, property bond, cash bond, and then compare with unsecured bail bond. Okay, it's very interesting that. So in this example, we issued the bond, right, which is evidence of a debt, and that debt will come true under the condition of if there's ever an accident between me or another party and the vehicles involved on the roads. Okay, so if that came to pass, we would effectively act as our own insurance through the straw man when being presented with the bill to cover the cost of the damages, whether it be with the hospital and or the car, your car and their car, okay, no matter who was at fault. And then that bill, you would then be able to set off against this bond held ideally at the Department of Transport by virtue of them administering your straw man account and you coming in as the acceptor or endorser of the bill against this bond to be set off. Okay, so that's just how to think. So you need to be able to fully understand when an accident happens in order for you to then gain access to your rights to the bond that you issued in the first place, to negotiate those bills and deal with obviously everything in regards to tying off all the loose ends when it comes to a claim. Okay, and that's why once you're presented with the bill, if you know what to do with it under the Bills of Exchange Act and how you can access your trust that way, that's otherwise what these bonds are unlocking for us to do. Okay, but again, like I said, we'll dive deeper into it and have a much better, fuller understanding of that whole process, understanding. So you've got a cost bond, is a bond given by a litigant to secure the payment of court costs. Okay, a cost bond is a kind of surety bond that guarantees payment of court expenses. Generally speaking, surety bonds form a legally binding contract involving 3 parties, the principal, the obligee, and the surety. The party requesting the bond is the obligee. The party obligated to bind the bond is the principal. With cost bonds, the plaintiff is the principal and the court is the obligee. The bond is backed by the surety, which is an insurance company that ensures payment of claims if the contract's terms go unfulfilled by the plaintiff, if the plaintiff fails to pay. So you've got to think, the surety, we want the surety to be our trust account, okay, which is our straw man. We never want to step up as surety for it, but otherwise we almost want the father's name, okay, to be surety for the straw man. That's how I'm seeing it. For our benefit, the living individual. Okay, because then that will be directing the surety to step in, which will be the Crown, who owns the surname, the Crown, and all these folks, the public trustee, the Treasury, in order to come in and set off whatever is being brought forward by virtue and by way of all these different bonds. Okay, so just again, start thinking about these relationships, these roles now that we've got three entities that we can play and use to our advantage. So counterbond is a bond to indemnify a surety. Discharging bond, a bond that both permits a defendant to regain possession of attached property and releases the property from the attachment lien, also termed dissolution bond. See forthcoming bond. You've got executor's bond, a bond given to ensure the executor's faithful administration of the estate. See fiduciary bond. The English law did not require an executor to give bond because he was appointed by the testator and his authority was derived from the will rather than the court appointment. Some American jurisdictions do not require bond of an executor. In the majority of our states, a testator may be by will dispense with the executor's bond, but in absence of such testamentary provision, a bond will be required. So we've got fiduciary bonds is a type of performance bonds required of a trustee, administrator, executor, guardian, conservator, or other fiduciary to ensure the proper performance of duties, also termed administrator's bond. Okay, I've highlighted the ones that you guys might want to consider looking into a bit more in depth. Guarantee bond, a bond combining the features of fidelity bond and performance bond, securing both payment and performance. Okay, it's quite interesting. What is a fidelity bond? A fidelity bond is a form of business insurance that offers an employer protection against losses that are caused by its employees' fraudulent or dishonest actions. Also known as an honesty bond, this form of insurance can protect against monetary or physical losses. In Australia, fidelity bond is called employee dishonesty insurance, and in the United Kingdom it's called fidelity guarantee insurance. Okay. Interestingly, under the security agreement, there is also a fidelity bond that is issued. Okay, because it's kind of like we're employing a straw man to use for our benefit, but if it gets in trouble, then we're not held liable. Okay, and it can be we're basically indemnified. And here's the indemnity bond: a bond to reimburse the holder for any actual or claimed loss caused by the issuer's or some other person's conduct. Okay, so when we issue that bond to the state, if that straw man ever gets in trouble, well then we can't be liable. It can't be liable because we've issued an indemnity bond to the value of whatever is written on the bond. Okay, which already would have been securitized and end up on the accounts of either Vanguard or BlackRock or one of those institutions. Okay, that we can draw from to indemnify our vessel upon the high seas. You've got a judicial bond, a bond to indemnify an adverse party in a lawsuit against loss occasioned by delay or by deprivation of property resulting from the lawsuit. Judicial bonds are usually classified according to the nature of the action in which they are required. As with appeal bonds, injunction bonds, attachment bonds, replevin bonds, forthcoming or redelivery bonds, and bail bonds. A bond of a fiduciary, such as a receiver, administrator, executor, or guardian, is often required as a condition to appointment. So you've got license bond, a bond required of a person seeking a license to engage in a specified business or to receive a certain privilege, also termed permit bond. Okay, again, just think about us being able to administer our own court. You can pretty much then, set up our own government, as we know, become our own registry. We can then issue our own licenses or permit bonds, okay, in order to permit us to do certain acts within the realm of commerce in the name of a straw man, in the name of the Holy Ghost. Okay, and even think about it in our given name, because we're above the world and realm of commerce. If we come in at that level, then we've got permission to do pretty much anything apart from infringing on the rights, life, and liberties of other living individuals, men or women. So negotiable bond is a bond that can be transferred from the original holder to another. Official bond, a bond given by a public officer requiring the faithful performance of the duties of office. A bond filed by an executor, guardian, trustee, or other fiduciary. See fiduciary bonds. It's difficult with these bonds, though, to get them to issue it to us, but we can certainly request it. But there's ways you can bind them through a bond under the terms and conditions, okay, to kind of perform in a fiduciary capacity. Payment bond, a bond given by a surety to cover any amounts that, because of the general contractor's default, are not paid to a subcontractor or materials supplier. The bond serves two purposes. It assures the owner a lien-free project, and it induces suppliers and subcontractors to accept work on the project, perhaps at a lower price, because of the assurance that they will be paid. Since no additional charge is generally made for a payment bond when a performance bond is being purchased, the two are usually issued simultaneously. And you've got peace bond, a bond required by a court from a person who has breached or threatened to breach the peace, also termed bond to keep the peace, see breach of the peace. Okay, it's quite interesting. Probate bond, a bond such as that filed by an executor required by law to be given during a probate proceeding to ensure faithful performance by the person under bond. We have a replevin bond, which is a bond given by a plaintiff to replevy or attach property in the defendant's possession before judgment is rendered in a replevin action. The bond protects the attaching officer and ensures the property's safekeeping until the court decides whether it should be returned to the defendant. A bond given by a defendant in a replevin action to regain attached property pending the outcome of litigation. The bond does not discharge the attachment lien, also termed replevy bond, claim property bond, redelivery bond, see replevin, and compare with forthcoming bond. You've got a simple bond, a bond without a penalty. 2, a bond payable to a named obligee on demand or on a certain date. We've got 3, a long-term interest-bearing debt instrument issued by a corporation or governmental entity, usually to provide for a particular financial need, especially such an instrument in which the debt is secured by a lien on the issuer's property. Compare with debenture. So we have annuity bond, a bond that lacks a maturity date and that perpetually pays interest, also termed consol. Perpetual bond, continued bond, irredeemable bond. Remember, it was the Phoenicians, the prestiti, the previous presentation, the bond investing for dummies book, okay, which is quite interesting. And that's annuities. That's otherwise what's accredited in our account off the back of our bonds that are issued under the life insurance. And there's annuities that are paid out on that within the life of the said QV, which is one for whose life a trust is set up, okay, which obviously that corporation exists in perpetuity. And I wonder how many people have passed ever since this system was set up, that those accounts are still actually accruing interest or annuities, okay, on accounts under the so-called father's name, right? Which is very interesting. So bearer bonds, a bond payable to the person holding it, a change of possession transfers the bond's ownership. Okay, it's registered bond, as we know, the Committee of 300 document, remember, some of these accounts have been around for a very long time. So it's like King David out of the Bible, King Solomon, Moses, etc. So yeah, some of these have been around for a very, very long time. That's why it goes into the off-world interplanetary corporate empire structure too, which no doubt is going on as part of the super soldier talk guys that have exposed all that infrastructure, which then goes into the spirit worlds as well, okay, which is what's her name? I forgot her name. Jessie Sebotar, starting to bring forward with her affidavits of revealing how it all ties in with the spirit worlds and how that is translated also to currency of our life force and souls here on this plane. So it goes pretty deep, this structure. But it's all coming to an end. That's the great thing. You know, we're all coming back to our own power and thwarting the forces of darkness, as it were, and stopping them parasiting off of us. We're on a detox at the moment, an anti-parasitic awakening. The whole cosmos is going through. So bearer bond, a bond payable to the person holding it, a change of possession transfers the bond's ownership. Compare with registered bond. Collateral trust bond, a bond representing a debt secured by the deposit of another security with the trustee, also termed collateral trust certificate. Long-term corporate bond that is secured by other companies, mortgage bonds held by the corporation which pledges and deposits the mortgage bonds in trust. The interest on these collateral trust bonds is typically lower than that received on the bonds pledged. The surplus is used to form a sinking fund to redeem the collateral trust bonds. A holding company often issues these bonds by pledging the stock of a subsidiary. Okay, and I believe this is definitely what is going on a large scale. So key takeaways of a sinking fund. A sinking fund is an account containing money set aside to pay off a debt or bond. Sinking funds may help pay off the debt at maturity or assist in buying back bonds on the open market. Callable bonds with sinking funds may be called back early, removing future interest payments from the investor. The paying off early via sinking fund saves the company interest expense and prevents the company from being put in financial difficulties in the future. And this is why they're kind of loan out. There's a difference in the cash rate and the rate that is sold to us as consumers on the public side. Again, the difference is what they pocket and make for themselves to cover the expenses on those bonds. Remember, the investment bond as well that we issued stipulates that kind of condition in order to order them to make investments on our behalf, but provision, setting aside also a certain amount of those investments to cover the price, the interest, and the principal of the bond when it matures. So convertible bonds, a bond that can be exchanged for stock shares in the corporation that issued the bond. Corporate bond is an interest-bearing instrument containing a corporation's promise to pay a fixed sum of money at some future time. A corporate bond may be secured or unsecured. A bond issued by a corporation, usually having a maturity of 10 years or longer. Coupon bonds, a bond with attached interest coupons that the holder may present to receive interest payments. See bond coupon. Discount bonds, a bond sold at its current market value, which is less than its face value, also termed non-interest-bearing bonds. So we've got general obligation bond as a municipal bond payable from general revenue rather than from a special fund. Such a bond has no collateral to back it other than the issuer's taxing power, often shortened to obligation bond, also termed full faith and credit bonds. There are two main types of bonds issued by local governments: general obligation bonds and revenue bonds. Bonds will be assumed to be general obligation unless they themselves contain a clear promise to pay only out of a special fund. All right, it's quite interesting that. General obligation bonds, full faith and credit. Again, that's what's backing this whole system of us stepping up to believe we are the straw man and we've got something to oblige and perform and dance to with their acts. Okay, so it's all theatre. Isn't that interesting? Because it is a faith. It's the biggest religion ever. And it's all fiction. That's what they get us to believe in the Tooth Fairy, Santa Claus, and then they all condition us to believe that we are that mirror image, shadow self, Holy Ghost. So gold bond, historically a bond payable in gold, coin or US currency at the election of the bondholder. This type of bond existed until 1933, so we know what happened then, when the US monetary system abandoned the gold standard, a commodity-backed bond that is secured by gold and is issued by a gold mining company. So governmental purpose bond, tax law, a tax-exempt bond that is secured by the issuing government's revenues or whose proceeds are used by the government for a general purpose. Interesting. Guaranteed bond, a bond issued by a corporation and guaranteed by a third party. This type of bond is common among railroads, also termed endorsed bond, assumed bond, joint bond. 2, a bond issued by a subsidiary corporation whose parent corporation guarantees the principal and interest payments. Then we have insurance bond, a single premium life insurance policy designed to serve as an investment by accumulating a cash value that earns interest. Municipal bond is a bond issued by a non-federal government or governmental unit, such as a state bond to finance local investments. The interest received from a municipal bond may be exempt from federal, state, and local taxes, often shortened in plural to municipals or munis, also termed municipal security. Compare with ex-legal municipal bond. Okay, you've got participating bond, a bond that entitles the holder to a share of corporate profits but does not have a fixed interest rate. Passive bond, a bond bearing no interest. See passive debt under debt. Post-obit bond, an agreement by which a borrower promises to pay to the lender a lump sum exceeding the amount advanced upon the death of a person whose property the borrower expects to inherit. Okay, equity traditionally enforces such bonds only if the terms are just and reasonable, also termed post-obit agreement. Then we have a put bond, a bond that gives the holder the right to redeem it for full value at specified times before maturity, also termed multi-maturity bond, option tender bond. Okay, compare with put option under options with the futures and options derivative markets. Secured bond, a bond backed by some type of security. Okay, certainly what a lot of the bonds out there are, which we also have the terminology. We've got the remix, okay, and the widely held fixed investment trusts and the non-mortgaged widely held fixed investment trusts. Okay, so you've got kind of debentures in that regard and traditional bonds, which are normally backed by securities, okay, of some kind, a security of some kind, whether it's our lifetime pledge of labor, tax repayments, okay, insurance policy taken out in the name of our Holy Ghost trust account, which is basically what it's all leaned against. Okay, that's the security is the Holy Ghost, and them hoping that we're going to step up as surety for it. Sinking fund bonds, a bond backed by a sinking fund for bond redemption. See sinking fund under funds. Tax exempt bond, a bond that pays tax-free interest. Zero coupon bond, a bond paying no interest. It's sold at a discount price and later redeemed at face value, the profit being the difference, also termed passive bond. Okay, C, zero coupon security under security. So now we've got bond as a verb is to secure payment by providing a bond at the creditor's insistence. For example, Gabriel consolidated and bonded his various loans. Okay, so that's the whole idea of what's going on, consolidation of all these promissory notes, bills of exchange, loan agreements, that they get bonded, pulled together. So to provide a bond for a person, the company bonded its off-site workers. Okay, and this is obviously what we do when we're coming in, when bonding these folks to perform. So you've got bond covenant, a bond indenture provision that protects bondholders by specifying that the issuer may or may not do as by prohibiting the issuer from issuing more debt. See bond indenture, and that's otherwise what you see in the flesh of the text, right? Which is all part of how we're going to unlock our remedy and rights, okay, when protecting ourselves and operating in commerce. It's all down to the conditions stipulated in the bond indenture. Bonded of a person or entity acting under or placed under a bonded court official. Bondholder, someone who holds a government or business bond. We've got bond indenture. It's a contract between a bond issuer and a bondholder outlining the bond's face value, interest rate, maturity date, and other features. 2, a mortgage held on specified corporate property to secure payment of the bond. We've got a bondsman. 1, someone who guarantees a bond, i.e. surety. And 2, historically a serf or peasant, also called a villain, however you pronounce that. Also termed in sense 2, a bondman. Okay, it's quite interesting. Bond, traditionally, a sum of money, this is out of LexisNexis, a sum of money to guarantee payment of a debt or performance of an obligation, but now no longer used. Specifically, an instrument under seal, usually in the form of a depot, by which a person, the obliger, binds himself or herself to another, the obligee, to pay a specified sum of money on the occurrence or non-occurrence of an event or condition. The word bond is used more loosely to cover a variety of arrangements aimed at ensuring compliance. See also collateral, deed, deed poll, good behaviour bond, Griffiths bond, insurance bond, oblige, penalty bond, performance bond, specialty, treasury bond, etc. So you've got surety, someone who is primarily liable for paying another's debt or performing another's obligation, specifically a person who becomes a joint obliger. The terms of the undertaking being identical with the other obligers and the circumstances under which the joint obligation is assumed being such that if the joint obliger becomes required to pay anything, he or she will be entitled to complete reimbursement. Although a surety is similar to an insurer, one important difference is that a surety often receives no compensation for assuming liability. A surety differs from a guarantor who is liable to the creditor only if the debtor does not meet the duties owed to the creditor. The surety is directly liable. That's obviously what they've done to us. Okay. Compare with guarantor. The words, this is some commentary under the definition. So the words surety and guarantor are often used indiscriminately as synonymous terms, but while a surety and a guarantor have this in common, that they are both bound for another person, yet there are points of difference between them which should be carefully noted. A surety is usually bound with his principal by the same instrument, executed at the same time and on the same consideration. He is an original promiser and debtor from the beginning, and is held ordinarily to know every default of this principle. Usually the surety will not be discharged either by the mere indulgence of the creditor to the principal, no matter how much he may be injured thereby. On the other hand, the contract of the guarantor is his own separate undertaking in which the principal does not join. It is usually entered into before or after that of the principal, and is often founded on a separate consideration from that supporting the contract of the principal. Okay, it's quite interesting. Really important to get your head around this, because again, you can think within this relationship, we're obviously not acting as surety anymore. So what is coming in to kind of almost insure the straw man, the bonds that we issue, and the name of the Father, okay, which is the crown. And that's where all the money, they have the power, that's where everything's been administered. So they can come in, you can bind them as surety now on behalf of the straw man for your benefit, the living being, to be completely indemnified and separated from all this nonsense that's going on. It's just what I'm thinking. Obviously, it naturally comes to you when coming into this information, how you can play this now for the knowledge we have. Knowledge is power. A surety, teach you how to fish. Surety in the broad sense is one who is liable for the debt or obligation of another, whether primarily or secondarily, conditionally or unconditionally. In other words, the term surety includes anyone who is bound on an obligation which, as between himself and another person who is bound to the obligee for the same performance, the latter obliger should discharge. In this sense, suretyship includes all accessorial obligations. By such terminology, guarantors and endorsers are kinds of sureties. A surety, in the narrow sense, is one who is liable in form primarily on the debt or obligation of another. His obligation or her obligation is accessorial to that of the principal debtor, but it is direct and not conditioned on the principal debtor's default. In this sense, suretyship differs from guarantee and endorsement, which are conditional, secondary obligations. The word surety is in the majority of American decisions used in the narrow sense to indicate a primary obligation to pay another's debt, to distinguish it from the secondary obligation of a guarantor. This terminology has the advantage of indicating by the use of the one word, surety, an obligation which is at once one to pay another's debt, but which at the same time is not conditioned upon another's default. So it's far better for your corporate strawman, Holy Ghost, ens legis, government created fiction name to be insured and underwritten by the name of the Father. SEDIKV trust account, okay, which would be your surname with your birth certificate registration number, your that identity number, okay? And that's what you can otherwise come in to act as surety for, and you can sign on behalf of both of those entities. All right, and you can just sit back, pulling the strings, and not being involved in any of that crap and being brought down to that level. And through the Crown, because these guys can act in right of any instrumentality that they own, they've created, which includes your straw man, but none more so the name of the Father. Okay, so it should be, you should see now how you can tee this up, guys, right? When issuing your own bonds and indemnifying yourself and thinking how you can set things off, etc. So underwrite is to write beneath or to subscribe is of an insurer to execute and deliver an insurance policy. Okay, it's 3 to undertake to pay a pledge of money, a subscription, etc. 4 to engage to buy all the shares in a new venture company or other enterprise, especially when not subscribed for by the public, specifically to arrange to sell shares in a company while agreeing to buy any not sold to them. 5 to support an activity plan, etc. with money while taking on full financial responsibility for a failure. Okay, your underwriter is an insurer. The party who takes upon himself the risk is called the insurer, sometimes the underwriter, from his subscribing his name at the foot of the policy. Okay, again, the name of the Father. You can certainly subscribe that name as an underwriter and underwrite these securities and act as surety for the debtor, which will be the straw man. Okay, which the Crown would then, with all of their Crown instrumentalities, be able to be put to work when called upon to look after that strawman entity, which is also something that they govern and administer, but for our benefit. Okay, and that's where the public trustee will step in, the Treasury, and any one of these agencies that you're dealing with when you're issuing your securities and binding them to perform and coming in and underwriting these documents and securities in the name of the Father, that you can invoke them to then act through on these documents for your benefit in the name of the Holy Ghost. So it continues, the term underwriter derives its meaning from former British insurance practices when insuring their cargo shippers would seek out investors to insure their property. The insurers would add their signatures and would write their names under those of the shippers, hence the term underwriters. Okay, both in terms of the insurance industry and the securities markets, the concept of underwriting has expanded significantly since its inception. You've got banks, so we're going to go into the definition of banks now. So you can see how that's kind of all tied up the securities market quite nicely and negotiable instruments and bills of exchange. Okay, so we're going to go into the definitions of bank now. We obviously have one under the bills of exchange, but these are the other ones taken out of the legal dictionaries. It's got Latin banco, banca, shelf, bench, stool, money changers table. 2, land confining water. Banking and finance, an institution established to assume the custody of money and to undertake other financial activities such as the lending, exchange or issuing of money or the transferal of funds. The 3 main types of banks in Australia are authorised deposit-taking institutions that have been granted permission by the Australian Prudential Regulation Authority under the Banking Act to use the term bank and other bank-related terms. State banking corporations within the meaning of the Commonwealth Constitution and the Reserve Bank of Australia, which acts as Australia's central bank. Banks and banking business other than state banking that does not extend beyond the limits of the state concerned is regulated by Commonwealth legislation. Okay, see also, as you can see there. So bank, again, is a noun, and this is taken out of Black's Law, is a financial establishment for the deposit, loan, exchange or issue of money and for the transmission of funds organised in accordance with state or federal law, especially a member of the Federal Reserve System. Under securities law, a bank includes any financial institution if a substantial portion of the institution's business consists in receiving deposits or exercising fiduciary powers similar to those permitted to national banks, and if the institution is supervised and examined by a state or federal banking authority or a receiver, conservator, or other liquidating agent of any of the above institutions. Okay. 2, the building or office in which such an establishment conducts transactions. We've got commentary here. A bank is a quasi-public institution for the custody and loan of money, the exchange and transmission of the same by means of bills and drafts, and the issuance of its own promissory notes payable to bearer as currency or for the exercise of one or more of these functions, not always necessarily chartered, but sometimes so, created to subserve public ends or a financial institution regulated by law. A bank is wholly a creature of statute, doing business by legislative grace, and the right to carry on a banking business through the agency of a corporation is a franchise which is dependent on a grant of corporate powers by the state. All right. So, interestingly, even under their definitions, they're chucking around these terms like deposits and loaning funds, when in reality, that is not the case. Okay. And if you pick up, again, equivalent of a banking law in your given country and someone's commentary on breaking down the whole banking industry, then you'll see that even these guys know that the term bank and what they actually get up to is something completely different in regards to deposit, okay, and loaning out so-called deposited funds, because they don't. They're not in the business of doing that. They're in the business of taking loans from the public, okay, and that's otherwise what is codified under their statutes and acts, which I'm trying to find a brief snippet of out of this book. Okay, so it says here, the salient feature of modern banking is that it is fractional reserve banking. In simple terms, the bank lends its credit, not its money. The banking system as a whole is capable of creating money, a point recognised by the Campbell Committee as a feature common to banking in most countries. Okay, and there's another snippet as well mentioning this. It is an offence for a person other than a body corporate to carry on any banking business in Australia unless an exemption is in force. Banking Act 1959. The Banking Act 1959 provides that any corporation that wishes to carry on the business of banking may apply to APRA for the authority to do so. Banking Act. Okay. Okay, so it goes chapter 3, banker and customer, right? The basic relationship is contractual, and traditionally the terms of the contract were implied terms. It goes into the debtor-creditor relationship, and it references a case, okay, where Lord Cottingham LC said in 1848 between Foley versus Hill, okay, money when paid into a bank ceases altogether to be the money of the principal. It is then the money of the banker who is bound to return an equivalent by paying a similar sum to that deposited with him when he is asked for it. Money paid into a bank is money known by the principal to be placed there for the purpose of being under the control of the banker. It is then the banker's money. He is known to deal with it as his own. He makes what profit he can, which profit he retains to himself. He has contracted, having received that money, to repay to the principal when demanded a sum equivalent to that paid into his hands. Okay, some consequences. Any other finding would have made modern fractional reserve banking impossible. Had the court found that the bank was a bailee, a trustee, or an agent, the bank would have been saddled with additional obligations that would inhibit its function as a financial intermediary. For example, bailee, the bank would be obliged to return the exact coins and notes deposited with it. Trustee, Any investment by the bank would need to consider paramount the interest of the customer. The agent must always act in the interest of the principal against severely restricting the use to which the funds must be used. In both the trustee and the agent relationship, the bank would be required to account for profits, making modern banking impossible. The debtor-creditor relationship also has some unusual consequences. Okay, the important point is that the money belongs to the bank. The customer has a chosen action, namely the right to demand payment under certain terms, the most important of which is that the debt is not due until a demand is made. Okay, so it's a very important concept to take away. All right, so the debtor bank is not liable to pay the full sum until a demand is made by the customer, and the bank is under no obligation to seek out the creditor customer to make repayment when the debt is due. Okay, so yeah, some very interesting concepts there. The proceeds, yeah, anyway, so it goes into a lot of case law as well, and commentary surrounding that even though under so-called definitions and their acts and codes, they're not really depository taking institutions, okay, and they don't offer loans. They're in the business of purchasing securities and not loaning out other depositors' funds either, because we're the ones that create the credit. And when we sign that loan agreement, that is the note and security that is otherwise negotiated and that they purchase, in other words, negotiate at the Fed's window. So I'm just going to show you guys a beautiful snippet of an interview. I remember seeing this years and years ago. I think it was on Bloomberg or somewhere, but it's popped up again thanks to someone in the group, Roxine.
Money out of thin air. Yes, well,
So we're just going to watch this. Okay, this really, really emphasizes what we just covered about how banks are not depository or lending institutions.
Of the view that banks create money out of thin air. Yes, well, I produced the first empirical studies to prove that in the 5,000-year history of banking. Banks are thought of as deposit-taking institutions that lend money. The legal reality is banks don't take deposits and banks don't lend money. So what is a deposit? A deposit is not actually a deposit. It's not a bailment. It's not held in custody. At law, the word deposit is meaningless. The law courts and various judgments have made it very clear if you give your money to a bank, even though it's called a deposit, this money is simply a loan to the bank.
That's true. Yeah.
So there is no such thing as a deposit.
So you think it's loans to the bank. Named then.
So banks borrow from the public. Okay, so that much we've established. What about lending? Surely they're lending money. No, they don't. Banks don't lend money. Banks, again, at law, it's very clear, they're in the business of purchasing securities. That's it. So you say, okay, don't, confuse me with all that legalese. No. I want a loan. I want a loan. Yeah. Fine. Here's the loan contract. Here's the offer letter, and you sign. At law, it's very clear. You have issued a security, namely a promissory note, and the bank is going to purchase that. That's what's happening.
Put it in layman's terms. What does that mean?
It means that what the bank is doing is very different from what it presents to the public that it's doing. How does this fit together? So you say, fine, the bank purchases my promissory note, but how do I get my money? I want, it's a loan. I want
200 grand, right?
I don't care about the details. I want the money. The bank will say, well, you'll find it in your account with us. That would be technically correct. If they say, we'll transfer it to your account, that's wrong, because no money is transferred at all.
It's already
from
in the bank.
Anywhere inside the bank or outside the bank. Why? Because what we call a deposit is simply the bank's record of its debt to the public. Now, it also owes you money, and its record of the money it owes you is what you think you're getting as money, and that's all it is. And that is how the banks create the money supply. The money supply consists to 97% of bank deposits, and these are created out of nothing by banks when they lend, because they invent fictitious customer deposits. Why? They simply restate, slightly incorrectly in accounting terms, what is an accounts payable liability arising from the loan contract having purchased your promissory note as a customer deposit, but nobody has deposited any money. I wonder how the FCA deals with this, because in the financial sector, you're supposed to not mislead your customers. Anyway,
I don't think the answer
so the banks create the money supply by inventing these claims on themselves, the fictitious deposits. That can be actually positive for the economy as long as this money creation is in line with the creation of new goods and services, implementation of new technologies, and therefore adding value. And adding value in the economy is funded by this money creation. If that happens, and we're talking about business investment, productive loans, productive bank credit, you will have no inflation. These loans can also be serviced and repaid. You have a stable economy without problems and with low inequality. And so countries that achieve this, that the banks lend mainly for productive purposes, whether it's Germany in much of its 200-year history, or in the last century, the East Asian economies where bank credit was largely for productive purposes, then you find. But there's two more cases. I quickly need to point them out because that's the contrast.
But just clarify that inequality is significantly lower?
Lower, yes.
Inflation is low?
Yes, and you have stable growth.
And the real economy thrives.
Is booming, yes. That's when bank credit creation is focused on productive lending for productive purposes.
As opposed to speculation and asset price.
As opposed to, there's two other types. If banks create credit for consumption, it's obvious what's going to happen. You suddenly have more money created and more demand for goods, but it's the same amount of goods and services. So you're creating consumer price inflation. That's well understood, and central banks are watching that a little bit.
And
what's less well understood is, and what's the biggest in the UK, there's probably more than 70% of all lending, actually way more than that, is bank credit creation, so money creation for financial transactions, for asset transactions, for purchasing ownership rights. Now then you have a problem. Why? Because you're creating new money, but you're not creating new goods and services. You're simply,
they're constant, aren't they?
You're giving somebody new purchasing power over existing assets, and therefore you must push up asset prices. So this, you can draw a chart where you show, asset prices, land prices, property prices in the UK, and it will match very closely as I've shown in Japan and other countries. And that also creates the inequality. So when the banking sector has focused too much on unproductive lending, and in the UK it's dominant.
It strikes me that what you're telling me, and tell me I'm wrong, is that lending, in order to get round this deposit/loan situation, needs to be categorized.
You're right, exactly.
Is that right?
That's right. We need to look at where the money is going. That makes a whole world of difference. Okay. So if money bank credit is extended for productive purposes, you're fine. You get a good economy, no inflation, and financial stability. And also, you don't have this inequality problem.
And do you think there should be different capital ratios towards each?
Capital, the whole Basel capital approach doesn't work. Why? Because it's premised on the idea that banks are just financial intermediaries. But they're not. They're money creators. We need bank regulation that recognizes reality of how the banks actually operate.
So what you're saying, this is a regulation problem?
Clearly, yes, it's a regulation problem. That's right. We need different regulation. And the only regulation that actually has succeeded in history, and we have good data for the 20th century in particular, in preventing asset bubbles and banking crises, which are all driven by this bank credit for financial transactions. Leads to this asset boom, and it's a game of musical chairs. You have to play it. It's rational to play it while the music is playing, which is how asset prices are driven by ever more bank credit for financial transactions. The moment it stops, asset prices fall. You get the first bankruptcies. Banks get risk averse. The whole thing goes into reverse and banks go bust. But you can avoid this, and the only regulation that has succeeded in avoiding this is guidance of bank credit. Simple rules. The simplest form of bank credit guidance is to simply ban bank credit for financial transactions. It doesn't mean financial transactions are bad. No, let the speculators speculate and let them even borrow money, but not from banks. That would make a whole world of difference.
Who do they borrow it from?
Well, they can issue bonds or, borrow in the markets, whatever they want.
But that's risk reward.
But they shouldn't get access to the public privilege of money creation, you see.
I know what you mean, yeah.
And that creates the problem, that creates the boom-bust cycles. But in some countries, they've succeeded in preventing this asset inflation.
Which ones?
Such as Germany, without even credit guidance, by having a banking structure, a banking system that's dominated by banks that don't want to do this financial speculation in the first place. These are the community banks. So Germany with 70% of
What do you call
banking
the Landesbank?
being
Yeah.
not
No?
the Landesbanks, the smaller ones, the 1,500
Right.
Volksbanken, Raiffeisenbank.
Okay.
They're actually the main banks in Germany. There's so many of them. Each is small, and they lend mainly for productive purposes to small and medium-sized enterprises. The Mittelstand, which has been the backbone of German economic success for the last 200 years, despite wars and disasters, has only been successful because they also have their local small banks funding them all the way through. That doesn't exist in the UK, and that's been why the small and medium-sized enterprise sector always has had a problem in the UK.
So we're stuck with speculation and horrific property porn renovation shows.
Well, the solution is, of course, to create these small banks. We need to create small banks. They're the natural lenders to small firms. The public wants stable growth, none of this boom-bust cycle, banking crisis, public money used to bail out banks. People don't want that. In Germany, these community banks,
It's very interesting
dominant,
because
they've never used public money. In these 200 years, not a single one has ever been bailed out with public money, and no depositor has lost any money.
Although, Richard, your argument is complex, principles are terribly simple.
It is very simple.
And although
Well,
you're a little defeatist,
I'm not. Maybe I'm defeatist, but I like it. But it's just the idea of how can I put it?
Go on.
Getting through the regulatory. They are so reluctant.
but that's why
It is hard work.
But that's
It's
why
hard
we got you in. We're gonna have you as
I
the
think
ambassador.
I have to say this has been brilliantly explained.
We open with the question: do we have a finance curse? Does the UK have a finance curse, David?
No. I think it has difficulties, but I think those difficulties have appeared insurmountable 5 years ago. Now I think the occasion says that it's much better, but there is this severe danger of over-regulation, which is completely understandable, not wanting a replication of what happened in 2008.
Has the UK got a finance curse?
Is it a trick question? Because the UK doesn't have finance. The City of London has, and is not part of the UK.
Good answer. Good answer. It's international, he's right.
The City of London is outside the United Kingdom. Do you know that? It's really shocking. And therefore it's also not part of the EU, which explains although it couldn't be part of the EU because you have to have democratic elections, and the City of London doesn't, right? It's the banks that have the votes, right?
Right.
Per staff, you know.
I never knew
How
that.
do you start unpicking this puzzle?
I never knew that. That's a very useful piece of
And
information.
of course, it's not part of the
pretty
UK.
dangerous piece of information.
And it's not part of the UK because the Queen is not allowed to enter without permission. She's not the sovereign, therefore it's not part of the UK. It's, and of course that's since 1688.
I have to make a note.
Since the foreign invasion.
There you go, David. That didn't.
So there you go. It's very well put, well explained. That kind of whole concept, right? If you weave it into what we know, with the deeper aspects of this, which he probably does know, but he was very careful to obviously not go too in depth about it. But be interested to get hold of that guy's books, whatever his name is. So I'll probably do some digging and try and share that, because it'd be good to look at his reports as well, if any books that he has published that goes into the history surrounding the City of London and what's going on there. So that'd be quite interesting to read. So to carry on, financial institution, an entity that accepts money as savings or investment and in turn provides funds to borrowers such as a bank, building society or credit union. The term financial institution is variously defined in legislation to include authorised deposit-taking institutions, cooperative housing societies, bodies corporate that are financial corporations within the meaning of Commonwealth Constitution, or would be if incorporated in Australia, anybody that carries on a business providing financial products or financial services, any institution that receives money on deposit, a person who carries on the business of banking outside Australia and the Reserve Bank of Australia, for example, Proceeds of Crime Act, etc. So you can see here that they're claiming that a bank is an authorised deposit-taking institution. We obviously know now that's not reality. So what are these institutions? So we can challenge that. We can certainly challenge that, their definitions, and expose what the banks are otherwise doing. Okay, we can back them into a corner when having this knowledge by asking questions. Show us the proof. You're claiming that you are this, but in reality, it seems to me that you're not. Can you please provide proof to the contrary? Who's the original creator of that note? How did you create credit? Where do those funds come from? Was it lent from another person's account, from the bank's balance sheet, etc., etc.? Okay, so again, once you know the knowledge, you know how to then, if you're in a situation where you can test in a mortgage, a loan agreement, you can just start asking questions, take your power back, and otherwise understand what these institutions really are and what they're getting up to, okay? And that we are the bank, and that it's us that create all the credit on an account. And so maybe even being able to set up an account where you are the creditor, and so that anytime that you do sign a loan agreement, you can otherwise receive it without having to pay it back. Okay, so I mean, that's my dream, and that's obviously part of what I put in with my so-called testamentary instrument here in Australia with the unclaimed monies. So, you know, as we accrete and grow, it's just going to become a lot clearer, the pathway in regards to how we can start negotiating our instruments and securities, and even, you know, within these institutions themselves with accounts, right, for our benefit. So another good one is the banking code of practice, which most of you folks, given the country you're in, you should be able to download online and read through, which is important to read through, but just emphasize the most important aspect of this is how within the loan agreement, with the language, you and your means a person who at the time we provide the banking service or information is provided is our customer, okay? And we, us, and our means the bank. Okay, so it's important maybe coming forward because we know certainly we, us, and our, we're talking on behalf of two other entities besides ourselves that are banks, they're trusts, and they're corporations. Okay, and we know that we are the ones that otherwise create the credit within the system. And it's not money, it's credit. There's a difference in order to go off and obviously, you know, purchase things for our advantage. So whenever we write our letters, we want to be coming in, we, us, and our, and make them you, refer to them as you, but stipulate that. But obviously within that code, when dealing with banking, which is what this whole system is operating under, we always want to be claiming we, us, and our. Okay, so very, very interesting. Get your hands on that and read through, and it can otherwise show you other key snippets as well and tidbits as to what's going on. So however, banking services, the code does not apply to include shares, bonds, and other securities that we issue. Chapter 7 of the Corporations Act, so I went off and saw that. In other words, went through that, okay, which isn't going to really be relevant for you folks in this presentation, but we're going to quickly go through the Reserve Bank Act here in Australia that reveals, you know, some pretty interesting things. So general powers, the bank has such powers as are necessary for the purpose of this act and any other act conferring functions on the bank, and in particular, and in addition to any other powers conferred on it by this act, in such other acts has power, you know, to receive money on deposit, borrow money, lend money, to buy and sell. You can even challenge that. You really receiving money on deposit. Okay, you're really lending money. To buy and sell securities issued by Commonwealth and other securities. Okay, so this is where we can maybe get these guys to buy securities that we may be able to draft up. Okay, just an idea. 13, Governor and Secretary to Treasury to establish liaison. So the Governor and the Secretary to the Department of the Treasury shall establish a close liaison with each other, shall keep each other fully informed on all matters which jointly concern the bank and the Department of the Treasury. Okay, so we know these two are in cahoots for sure with what's being issued, with all the citizenry being pledged to these guys that acts as security to back all these securities, okay, these loan obligations. Membership of a Reserve Bank Board. The Reserve Bank Board shall consist of the Governor, the Deputy Governor, the Secretary to the Department of the Treasury, and 6 other members who shall be appointed in writing by the Treasurer in accordance with this section. 2, of the 6 members appointed under paragraph 1D, at least 5 shall be persons who are not officials. Okay, it's interesting. A member appointed under paragraph 1D who is an official at the time of his or her appointment holds office during the pleasure of the Treasurer. A member appointed under paragraph 1D who is not an official is to be appointed for a period not exceeding 5 years. All right. So, yeah, it's interesting to see how these are structured, these central banks, which I'm pretty sure all over the world is going to be the same. Declaration by members. A member of the Reserve Bank Board shall, before entering upon his or her duties or exercise any power under this Act, make before a Justice of the Peace or Commissioner for taking affidavits an oath or affirmation of allegiance in accordance with the form in the schedule to the Constitution and a declaration of secrecy in accordance with the prescribed form. How interesting, because these guys would know exactly what is going on. Okay, so maybe when trying to unlock getting access to the credits, we want to be addressing some of these folks, okay, who are on the board, and otherwise mention that. And it's interesting how they also have an affirmation here. So it's either an oath or affirmation. If you guys recollect, an affirmation is a lot cleaner word because you're not swearing an oath, which blasphemes their Bible. There's a chapter in Matthew, okay, where it says to swear no oath. So governor and deputy governor shall be appointed for such period not exceeding 7 years as the treasurer determines. Okay, that's the governor and deputy governor. And they are to be appointed by the treasurer. So the treasurer is very powerful in this regard and influencing what goes on in the central bank. 36, notes to be legal tender. Australian notes are legal tender throughout Australia. For the purposes of subsection 1, an Australian note of a denomination specified in the first column of the following table has the value in the currency provided for by the Currency Act 1965 that is set out in the second column of that table opposite to the denomination of that note. I just found that very interesting that was in there. Again, that otherwise kind of sets the benchmark for the exchange rate that should be kept against the British pound sterling, which, obviously has dipped down below, given, the scale of the amount of money in circulation at the moment, how difficult it is to kind of balance the extreme leverageness of this system. But they try to maintain it around the 2 spot mark, okay, in regards to £1 equals $2. So 44, other persons not to issue notes. Now this is important. A person shall not issue a bill or note for the payment of money payable to bearer on demand and intended for circulation. Penalty, 50 penalty units. Okay, Chapter 2 of the Criminal Code sets out the general principles of criminal responsibility. And 2, a state shall not issue a bill or note for the payment of money payable to bearer on demand and intended for circulation. Okay, so that you're going to be so careful, other persons not to issue notes. So yeah, when obviously going through their acts and making sure that you're doing things by the book, when issuing bonds, it's obviously different. But I guess with the notes here, meaning issuing notes similar to that looks like Australian dollars, okay, which is otherwise forgery, and it's codified under here. But it could also categorize an international promissory note or something like this. So just be careful, guys, when going through their acts. Make sure you're indemnified first before you do anything of the sort when starting to draft up your own securities. So you've got Section 79, which is interesting, taxation. The bank is not liable to taxation under any law of a state or of a territory to which the Commonwealth is not subject, and the income of the bank is not liable to income tax under a law of the Commonwealth. And I mean, perfect snippet that you can, guys, when you formulate your own terms and conditions that you want to send in to these folks in claiming your tax exempt status. Okay, that you can certainly do, that these guys otherwise do and operate, because they're the ones that otherwise receive the tax that you pay, everyone else pays and steps up to pay, which services the interest during all the debt owed to them, which just ends up becoming income, all right, on their profit and loss sheets. So it's got Corporations Act 2001 definitions. I put that in there just to, again, decipher more of the definitions surrounding some of these terms. Okay, I'm not going to read through it. You guys can go through it in your own time. This is obviously specific to Australia. And, again, some of these terms that are of interest to us, okay, which goes into the ASIC, which is the Australian Securities Investment, whatever it's called, committee, which governs the equivalent of the SEC, professional investor. So just getting used to the vernacular, okay, so you can find the equivalent laws in your nations and go through and just see what stands out to you, and again, copy and paste onto a document. Got the Financial Sector Collection of Data Act 2001, and again, trying to find out what they're saying a financial sector entity is. As we know, it doesn't seem to rhyme with the truth in regards to what these banks are actually doing. Okay, so there's definitely discrepancy there, and they're lying to the general public, as we know, being very deceptive. So this is how they're running the plantation. Commonwealth Inscribed Stock Act, again, is a very interesting one that I'm going to read through. Depositary interest means a beneficial interest in stock issued by a depositary nominee as a depositary nominee. Depositary nominee means a person who, with the agreement of the Commonwealth, issues to someone else one or more beneficial interest in stock. The person, you've got to think of our birth certificate, okay, owns legally or would own beneficially apart from the issue of those interests, has a beneficial interest in. We certainly have stock to the Commonwealth, unclaimed monies fund, consolidated funds, Treasury suspense account, the SEDI KB trust account. Stock means stock Treasury bonds, Treasury notes, or other prescribed securities created under subsection 4.1. Stock, however described, created under subsection, as enforced at any time before the commencement. Treasury bonds, debentures, or other prescribed securities made out under subsection 51. Issue of stock, the manner in which the prices at which and the terms and conditions, including terms and conditions as to redemption and interest on which stock may be issued and sold, shall be as directed by the Governor General and may be issued to a person on trust for other persons. Interesting. So payment of principal and interest on stock and related amounts connected with depository interests. The Consolidated Revenue Fund is appropriated to the extent necessary for the payment of principal secured by stock, interest on that principal, amounts that are to be paid by the Commonwealth to depository nominees or depository interest registry operators for payment by or on behalf of the depository nominees to holders of depository interests on account of either or both of principal secured by stock in which the depository interests are beneficial interests and interest on that principal. Okay, so good one to decipher if you can find it similar. But the other is revealing what's going on with how the depository nominees now are getting involved. Okay, which would be computer share here in Australia, DTCC in America. Arrangements related to stock and depository interest on behalf of the Commonwealth. The Treasurer may enter into, vary, administer, or otherwise give effect to a contract, agreement, or arrangement relating directly or indirectly to one or more of the following: the issue, management, or transfer of stock or depository interests. Okay. Services related to one or more of the following: a registry that relates to stock or depository interests, a clearing and settlement facility, and depository nominees. All right, so again, just showing the powers beholden that we can otherwise exercise these guys to work for our benefit when accessing our remedy in negotiating certain instruments. Limit of number of names. No stock shall be inscribed in the names of more than 4 persons. Stock certificates. Okay, the registrar must, when requested by a person who is the owner of the legal interest in any stock, issue to the person a certificate stating that the person is the owner of the stock. There you go. That's what happens when we're born. A certificate or birthed. A certificate issued under subsection 1 is prima facie evidence that the person specified in the certificate is the owner of the legal interest in the stock so specified. Okay, just think again, birth certificate, what is that printed on? Security stock paper. All right, preservation of equitable interest without prejudice to the provisions of this Act relating to the transfer of the legal interests in stock and notice of trusts. It is the intention of this Act that equitable interest may be forced against the owners of legal interest in stock in the same way as equitable interest may be enforced against the owners of legal interest in other personal property. Okay, then we've got transmission application. A person to whom the legal interest in stock is transmitted may apply to a registrar to be inscribed as the owner of the stock in accordance with regulations. Verification of transmission. Every transmission application shall be verified by statutory declaration or in such other manner as the Treasurer allows. And in the case of a transmission consequent on death, the probate of the will, letters of administration or other instrument authorising a person to administer the estate of a deceased person shall be produced to the registrar. Okay. Just think about what's gone on with what's happened to us at birth. So where an amount of stock not exceeding the prescribed amount is inscribed in the name of a person who has died, the Treasurer may dispense with the requirement of paragraph 1A, may authorise the transmission of the stock to such person as he or she thinks fit. Okay. Very revealing. 44, evidence. In any proceeding, a certified copy of an entry in a stock ledger or an extract from an entry in a stock ledger, or a document in the custody of a registrar that relates to stock is admissible evidence. And you can almost relate the books upon which we are entered in at birth. Are they keeping a ledger, do you think? Possibly. What do they issue? Stock certificate in exchange. All right, so again, falling under the category of evidence. So penal provisions, false personation. Any person who, with intent to defraud, falsely impersonates any person entitled to the legal interest in any stock or to any money payable in respect of any stock commits an indictable offence. Penalty, imprisonment for 10 years. I mean, a lot of these guys are coming in to claim power of attorney. So once you revoke all powers of attorney, claim back control of your straw man entity. And anyone coming in, any person coming in who falsely impersonates and misrepresents themselves as our Holy Ghost straw man, which is our property, then there's a penalty there that you can penalise and otherwise put under your fee schedule. Again, think about amending and quoting more domestic acts, saying, well, this is what you guys say, so if you guys come in and plunder my estate and use that entity, misrepresent, falsely impersonate, right, then you're liable to the penalty under the Act. So Treasury bonds, power to make out and issue Treasury bonds. The Governor General may authorise the Treasurer from time to time to make out bonds called Treasury bonds or Australian Consolidated Treasury bonds, debentures, and such other securities as are prescribed. So you can see the chain of command there. Governor General tells the Treasurer what to do, and the Treasurer otherwise permits a lot of what happens within the central bank. Okay, so the Governor General's like the head honcho. Conversion of stock, Treasury bonds, and other securities. Stock may, in the prescribed manner and on such terms and conditions as are prescribed, be exchanged for Treasury bonds, debentures, or other prescribed securities, and Treasury bonds, debentures, and other prescribed securities may, in the prescribed manner and on such terms and conditions as are prescribed, be exchanged for stock. So stock certificates, etc., not liable to stamp duty. So again, where I found that they're kind of coming away from using stamps. The following instrument and document shall not be liable to stamp duty or other tax under any of the other law of the Commonwealth or of a state or territory unless they are declared so to be so liable by the prospectus relating to the loan in respect of which they are issued or used. And there's a list, of all the securities. Stamp duty or other tax under any law of the Commonwealth, law of a state or law of a territory is not payable in respect of any inscription, transfer or transmission of any interest in stock that is effected by electronic means. So the transfer of shares is a voluntary act by the holder of shares and takes place by way of contract, whereas the transmission of shares takes place due to the operation of law, that is on the death of the holder of shares or in an event where the holder becomes insolvent or lunatic. So while transfer refers to voluntary ownership, change between two living eligible entities, transmission relates to automatic vesting of shares under inheritance laws post-demise of original shareholder through succession rights or execution of legally registered wills bestowing the securities to nominees. What is inscribed stock? Certain stock, usually government stock, may be inscribed. This means that certificates are not issued to stockholders, but their names are inscribed in a record book. Inscribed stock, stocks and shares, the ownership of which is simply recorded in a register with no share certificates issued. Inscribed stock comprises Treasury bonds and securities issued by semi-government authorities. For example, Government Loan Act. Okay, see also share Treasury bond. That's out of the LexisNexis. So we've got in this act as well, bank includes, but it's not limited to, a body corporate. That is an ADI for the purposes of the Banking Act, even though they're not deposit-taking institutions. So you can certainly challenge that. Liability of interest, income tax, notwithstanding anything contained in any other act, if in any prospectus or form of application issued in relation to a loan raised after the 12th of September 1931, it is so declared, the interest derived by any person in any financial year from that loan shall be free from income tax payable under the law of the Commonwealth to the same extent as interest derived from new securities referred to in Section 20 of the Commonwealth Debt Conversion Act 1931. Now I'm seeing that as if any securities issued after 1931 you have to pay tax on. Isn't that interesting? Which is kind of like on the interest accrued and earned, derived, from any person in that financial year from the loan shall be free from income tax payable. Isn't that interesting? So you can quote that. People will probably still pay in tax. So again, tax is also a voluntary action, that otherwise these guys, the Reserve Bank, are indemnified from. This is the Inscribed Stock Act. Record of unclaimed interest. Each registrar is to keep a record of the persons whose names are entered in a stock ledger as the owners of legal interest in stock, and in respect of whose stock a claim for interest has not been made for at least 10 years. The record may be kept by electronic means. The record must include such particulars of the address and occupational description of each person as are entered in the relevant stock ledger. A registrar must, on payment of this prescribed fee, make the record available for inspection by any person. So again, another thing that I'm going to do, ask him how much they need, whether I can access any reports or records, that are kept in my name or the Holy Ghost name, that these guys are holding on account within their books. So we'll Reserve Bank of Australia website. Out of there, there's this information, registry services. The Reserve Bank of Australia provides registry services to the following official foreign institutions who have Australian dollar denominated debt issuance programs: Asian Development Bank, African Development Bank, Council of Europe Development Bank, Inter-America Development Bank, okay, and all these institutions. Then services provided include issuance of securities, transfer and registration of securities, distribution of interest payments and redemption securities proceeds at maturity. Additionally, the RBA provides encashment of physical securities in circulation on behalf of the Australian Office of Financial Management for Australian government securities. The Commonwealth Registry of Inscribed Stock is no longer maintained by the Reserve Bank of Australia. Computershare Investor Services commenced management of this registry on the 4th of February 2014. Okay, all Commonwealth Registry inquiries should be directed to Computershare. Okay, so we see all these being able to register the securities that we may want to register, okay, and sell on the markets or issue. You're going to deal with here in the Commonwealth, especially Australia, Computershare. Okay, we've got banking services. The Reserve Bank of Australia provides specialised banking services to the Australian government and its agencies, other government instrumentalities, other central banks, and overseas official institutions. The Reserve Bank provides a facility to the Australian government that is used to manage a group of bank accounts known as the Official Public Account Group, the aggregate balance of which represents the government's daily cash position. These banking arrangements include the consolidation of agency account balances held with transactional bankers into the OPA group, the processing of daily payment instructions from the OPA to fund agency bank accounts, daily reporting, and access to a strictly limited overdraft facility. The Department of Finance manages this facility on behalf of the Australian government. The Australian Office of Financial Management has responsibility for ensuring there are sufficient cash balances in the OPA group to meet the government's day-to-day spending commitments and for investing excess funds in approved investments. The Reserve Bank provides the AOFM with a cash management facility for the investment of the Commonwealth's cash with the Reserve Bank. The Reserve Bank also provides transactional banking facilities to the various Australian government agencies. The main transactional banking services offered by the bank includes, there's a list, okay, and agencies can access these services and all related reporting by using the Reserve Bank's online banking service, API gateway or secure connectivity channel as applicable. Okay, and then Computershare, that's obviously the guys now dealing, which are the Depository Trust Clearing Corporation equivalent, okay, dealing with all of our monies, okay, within this infrastructure. Where the Treasury is there, look, with the central bank, Federal Reserve, and that's the window in which all of these things are being securitized and then made available onto the markets by virtue of being issued, transferred, registered, and distributed. Okay, so yeah, there we have it, guys. Hope that's been very educational. It's a lot of homework you're now going to have to do, as well as myself, to just embed it, go over it, become an expert in these things, and then naturally be able to start seeing the map, the roadmap. It's quite obvious, especially if you can get your hands on this, understand the relationship, what's going on with the Holy Trinity, our birth, and where we can come in now in the correct capacity, playing the correct roles and assigning the correct roles to all of these persons that we are able to put to work for our benefits. Okay, all right, guys, thanks for listening. I'll see you over in the next one. Ciao for now. Stay safe, and as always, stay sovereign. Cheers. Bye-bye.